All these guys. Thank you.
I'd like to call the January 19th meeting of the Quincy City Council to order. Mr. Clerk, if you call the roll.
Council Kane. Present. Council Kroll. Present. Council DeBon. Present. Council Finn.
Present.
Council LaForest.
Present.
Council Yang.
Present.
Council Palucci.
President.
President Hughes.
Present.
We have one.
All right. If you'd all stand, please. If we could have a moment of silence for the men and women in uniform here and abroad serving our country. And if you please join me in the Pledge of Allegiance.
I
pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. All right. This time, I believe I'd like to recognize Joe Finn, Councilor Finn.
We have a tradition at the City Council that started with President Peter Colson of passing on the gavel to the new president, so to speak. And when I look at the agenda before us this evening, I can't tell you how relieved I am to be doing that. But I have great trust and faith that you're going to do wonderful in this job. I think the amount of respect for other people's opinions, your willingness to have an open conversation have been on display in the past in your service as a counselor. And again, with that, I would like to present to you the gavel that you will never use beyond this evening, I'm sure.
I don't know about
But
that.
congratulations.
All right, thank you very much. Thank you. Yeah, I don't know if I won't use it, but I won't need it. I don't know. Sometimes Councilor Pellman should it's out of him. No. Very well. Thank you very much. We will move on with the first agenda item.
First agenda item, Madam President, is, I must read the open meeting law.
There you go. Open meeting.
This is Mass General Law, Chapter 38, Section 20E. Pursuant to the open meeting law, any person may make an audio or video recording of this public meeting or may transmit the meeting through any medium. Attendees are therefore advised that such recordings or transmissions are being made, whether perceived or unperceived by those present, and are deemed acknowledged and permissible. Thank you.
Thank you, Mr. Clerk. Now, if you'd like to
First
proceed with
item.
the agenda.
On the request of Director of Municipal Finance, with approval of his honor the mayor, the sum of $15,000 is transferred to the Port Security Grant of 2016. This is the purpose is to match a requirement of the city to match the grant. Same to be transferred from police repair and maintenance account. The grant award of $25,000 will then be set up for $60,000. Chief is present.
Thank you,
Recognize Councilor Kroll.
thank you, Madam Chairman. The chief is in attendance and he's going to sort of expand on what we have in front of us here this evening. I do want to just point out the cooperation of Chris Walker from the mayor's office in helping me as a finance chair to get the appropriate parties in the room, number one, and attach subsequent backup. So we really do appreciate that. And Chief, it looks like you have a grant opportunity in front of us, roughly 75 cents on the dollar reimbursed. Can you care to expand on that a little bit?
Thank you, Councilor. Good evening, Madam President, and new councilors especially. Congratulations. I'm pleased to be before you to request a transfer. What I'm looking for is a transfer of $15,000 from our repair and maintenance line in this year's budget, so there's no new money going into the account. We received a $45,000 port security grant. That grant will be utilized to repair and replace actually and install 2 new engines on one of our boats. It's the smaller of the safe boat. Those engines have exhausted their lifetime on the engines, the hours that they're viable, coming to an end. So we're able to luckily secure a port security grant for $45,000. Part of the city's requirement is a $15,000 match. I found that money in my repair and maintenance line, so I'm just going to request that we just transfer that money over so we can get going on that project.
So essentially, this money is already appropriated per the FY16 budget. You're just looking to move that to offset the grant and put us in the best position possible to secure the additional funding. Correct?
That's correct. It's just going from essentially one line item to the other. I believe I'll have enough money in that line item to carry me through the end of the fiscal year without any other issues.
So barring any questions from my colleagues, I move passage.
All right, is there a second? All right, motion made and seconded. Yes. Councilor Calhoun.
Chief, I just wanted to ask that you said that it's in the there's money in the repair and maintenance account already. First of all, good evening.
Good evening, sir.
Is that money that? Can you just talk about that account? I know we've over the past couple of years in previous budgets we've been buying new cruisers. We upgraded to the all SUV fleet several years back. I suppose what I'm looking for is you to tell me that this won't negatively impact our ability to keep cruisers on the road, that it's money that can be offset elsewhere, or was anticipated in that line item heading into the budget.
It shouldn't impact negatively. We've had a pretty good year, and let's put fingers crossed because we're coming into our season with anything can happen with these cruises. They're out 24 hours a day, but at this point, I don't anticipate that we'll have any issues. Most of the newer vehicles, they're up to date on their maintenance. Some of them are under warranty for a lot of the work. So I think we're in pretty good shape on that line item. So I don't think it's going to negatively impact the repair or the maintenance of any of the cruises. So at this point in time.
And just to kind of check in, where are we on the status of turning over vehicles? We must be in a relatively good place, given the commitment we've made in the last couple of...
We are in a decent position. There's always accidents, but we haven't had any major totals. We did total a vehicle. We're trying to get compensated for that through the insurance and Quincy Shore Drive. It was an unmarked vehicle. Unfortunately, the unmarked vehicles aren't quite up to where I would like them to be in the number of vehicles and also in the lifespan of those vehicles. Some of the unmarked cars are Tauruses that are 12 to 15 years old. So I may be coming forward. I'll have a conversation at some point with the mayor about potentially looking for some funding for that. But most of the new vehicles, all the frontline vehicles, we normally have 13 frontline vehicles. They're all brand new SUVs or within a year, or 2 years. Some of them are 15 to 14s. The second tier of vehicles, which would be the replacement vehicles, if a vehicle went out for maintenance or whatever, they're called spare vehicles. Those are all in halfway decent shape. Some of the vehicles, what we do is when we get new vehicles, we cycle them down to the units that aren't going 24 hours a day, like the community police unit or the school resource offices, so they're not in service for 24 hours. So we get a little bit more longevity out of those vehicles. So the marked cruisers, for the most part, are in pretty good shape. And the unmarked cruisers, I think we probably are going to have to pay a little attention to that this year. The unmarked cruisers would be for the detectives mostly.
Is there any, I know that the state law allows seizure of vehicles that are part and parcel to criminal activity, like a drug dealer's car. Do we get any actual utility out of that? Do we actually get those cars? Do we use them? I think in the past, either you or perhaps D.A. Morrissey told me that it's, most of the time they'll pull a car off the street, use it for a period of time, and then send it to auction. But is there any utility in using some of those vehicles?
We do that. The vehicles that are serviceable, that don't require a lot of maintenance, a lot of repair work, we may, once it's turned over to us, We may get a little bit of usage out of those. Sometimes they just auction them off, they're not worth repairing or whatever. Or some of them are too valuable. If it was a car that was worth, say, $50,000 or $60,000, we wouldn't take that. We would auction that off, we'd get rid of that vehicle, and get the funds with the split with DA Morrison's office. So we do sometimes get some service out of those vehicles. We also use DA Quirk. DA Quirk provides us with vehicles that are waiting for title a lot of times, so our offices, we go up and we change those vehicles around all the time. He's real good in working with us in that respect, so he'll give us a vehicle to use. Our undercover operators, our undercover detectives would use that for a brief period of time, and then when he needed it back, we'd go up and take another one. So we have a constant circulation of those vehicles. Sometimes we use the asset forfeiture money to purchase a vehicle, a cheap vehicle, if we're running short, $4,000 or $5,000 car, just to keep it going for a couple of years, and then we recycle through that one. But those would be the undercover, unmarked undercover vehicles. They wouldn't necessarily be for the routine detectives, or special investigations, or detective bureau.
All right, well, you've answered my question, thank you, and I suppose it's also good to know that you don't keep the Cadillac Escalades for the chief's car.
No, unfortunately, no. They haven't got anything that really caught my eye yet, but the expensive ones get rid of pretty quick.
Thank you. Thank you, Madam President.
Thank you. Further discussion? Seeing none, Mr. Clerk, would you call the roll?
Counsel King.
Yes.
Counsel Crowe.
Yes.
Counsel DeBon.
Yes.
Counsel Finn.
Yes.
Counsel Forrest.
Yes.
Counsel Liang.
Yes.
Counsel Calhoun.
Yes.
President Hughes.
Yes.
9 members of the office adopted.
Thank you.
Thank you, Council. Have a good night.
Thank you, Chief.
8 members of the office adopted. Next item is, Madam President, order that the city appropriate $6,000,007. This is a bond order for improvements in Beechwood Knoll and Marymount School advertising requirement. How will the superintendent see how much we
Yes, I did see Superintendent Mr. Barrow here, and he stepped out of the room for a moment, so, yes, Councilor Crowe.
Thank you, Madam Chairman. This item is actually going to be referred to financing. You did it already. I just wanted to point out that the superintendent, Dr. Sparrow, was in attendance this evening. And, upon agreement of the body, maybe we'll set up a subsequent financing meeting in the very near future. So let's see a presentation on this window replacement project.
Thank you. Thank you, Councilor. Next item.
Next item, Madam President, upon the approval of the Director of Parks, Forestry, and Cemetery Department, with the approval of one of the mayor, the sum of $50,000, hereby appropriate capital improvement cemetery account for the purpose of making funding repairs at Bluegill and Mount Wallison Cemetery and final permitting the Bluegill Cemetery expansion. Same to be transferred from reserve appropriation, Pine Hill sale of lots. Director Cassani is here.
Yes, recognize Councilor Crowe.
Thank you, Madam Chairman. Busy over here this evening. Ms. Cassani, Director Cassani, if you'd like to come to the podium and explain to us sort of the thought around the expansion of Pines Hill.
Good evening, everybody. Thanks
Mr.
very much.
Cassani.
Right now, we're rapidly running out of space at Pine Hill Cemetery. Currently, we do not do any pre-sale of any of our plots at any of our cemeteries. Currently, there are no plots for sale over at Mount Wallison Cemetery, so Pine Hill is the only place that we have active burials. We've been engaged in the kind of conceptual process of this project to expand Pine Hill Cemetery by approximately 7.5 acres for a few years now. Ultimately, if we want to accommodate for the needs of folks who pass away, we need to create more burial space. We're good for the next few years, but we certainly see a shortage coming, and obviously that's something we view that as a core service of what we do. That's something that needs to be addressed. Unfortunately, the expansion proposal that we have, the area that we're dealing with is environmentally sensitive. It requires some complex permitting for endangered species. There are snakes that are on site there that need to be managed in a very careful way. There's also wetland issues that need to be permitted, through the expertise of engineers and so forth. So it's something that unfortunately we can't handle extremely quickly, nor can we handle it in-house. We need to hire experts, attorneys, engineers, and so forth to do this. So I think we're at the 10-yard line trying to punch the ball over the goal line right now. We have a short way to go. We have a short way to go, and I would anticipate that this would be the last request for this particular type of transfer from me, specifically related. I think after this, we'll be able to get all of those permits that we need in order to start the process. And then, funding the ultimate expansions is a totally different matter that would require much more discussion.
Thank you. Council Pro?
When you talk about permits, obviously, the one that pops out is you've got to probably appear before some sort of conservation commission. What's sort of lead time on that? I mean, I know you say $50,000, 7 acres, that should take us into the relatively near future. What are you thinking in terms of sequencing?
So right now, we've had extensive discussions with the state, the national heritage, relative to the endangered species issue. So where we received a ruling from them that we had expected, we should be able to go ahead with our notice of intent in order to get our order of conditions within the next couple of months. Then the statutory requirements there, I think it's within 45 days or whatever the case may be, we'll have our permits in hand, which would then allow us to move forward with the actual execution of the vision.
So roughly 45 to 60 days to, for lack of a better word, restore the service. It's currently not being offered now.
No, we're able to sell plots. So if someone were to pass away, a Quincy resident were to pass away, we have space available at Pine Hill Cemetery right now to provide for whatever it is they're looking to do. Whether it's a single grave plot, which would allow 2 casket burials, we have some doubles and triples available. That capacity is rapidly dwindling. So this project, we're really looking multiple years down the line here, but once we're out of space, that's it. So it's something that needs to be addressed now, so that we kind of have a seamless transition, to that new wing of the cemetery.
Is there? Yes, there's actually no motion, I don't believe, on the floor, but discussion, Councilor Leahy?
Just a couple of questions. So, you said the 50,000 was for funding repairs and for the permitting. How much is going towards the repairs, and how much is going towards the permitting?
I would envision, my ballpark estimate would be about 35,000 will go towards the permitting issue, the permitting effort, which would be additional attorney fees, engineering fees, and then somewhere near about 15,000 would go towards typical run-of-the-mill maintenance type items. And just as a little bit more background on this, the funds that we're asking for, those funds are generated through the sale of lots at Pine Hill and through, those specifically from Pine Hill Cemetery. So it's kind of a revenue coming in, revenue going back into the cemetery of Pine Hill.
Thank you. Thank you. Any further discussion? Yes, Councilor Calhoun.
I'll make a motion that we pass, and then if that gets seconded, I have a question on the motion.
All right, there's a motion. Is there a second? Motion's been made and seconded. Further discussion?
Yes, ma'am.
Councilor.
Mr. Kasani, good evening.
The
Always a pleasure to see you.
pleasure's all mine.
Is does the cemetery area count as open space? Do you know?
It would be listed as open space on any open space maps that you see here.
So is that something that could be, we could utilize CPA funding for an open space portion of?
I believe that we potentially could. I believe that we potentially could.
And you said we have an attorney who's handling the permitting process?
Yes, we do.
Yes. Who's the attorney?
Richard Nyland, he is at a firm out of downtown. He handles specific issues related to the endangered species and that sort of thing.
And that's, anticipating my next question is why do we need outside counsel? It's because he has a specialty relative to endangered species.
Correct.
What is the final cost estimate to get what we need to get?
I would say, so right now there's been a whole slew of things that have happened in the last few years.
So maybe if you could.
Absolutely. We had Golden Environmental was a company that was lined up to do a survey. There was no existing survey of that cemetery. So there was an appropriation a few years ago, I want to say it was somewhere in the neighborhood of $35,000 to get that particular piece of the puzzle executed. We've had to bring in biologists, and we've been to the tune of $15,000 with them. We've had attorney fees along the way. The attorney has been with us throughout this entire process. And that's going back many, many years, even before I was the executive director. So at this point right now, we have some contracts that are encumbered. That should get us through all of our various, mechanical things, if you will. What I'm anticipating is that we're going to have additional needs throughout the notice of intent process and additional questions that the state's going to be answered. So I would, as I said before, my best estimate right now would be about $35,000 of the remaining of this particular appropriation would go specifically toward permanent effort.
And we've already purchased we already own the land for the expansion?
We are pursuing a land swap with what is state-owned land. So that's another whole layer of complexity that has made this process a little bit more onerous. Ultimately, we own land that we don't anticipate using for the cemetery. We're swapping for land that's more agreeable, if you will. There's a lot more gravel in the land that we're purchasing than there is in the area that we're giving back to the state. So that swap is obviously fairly complicated, thus necessitating this whole process.
The DCR has a history of land swaps relative to the Blue Hills. Some that I think sit with the stakeholders better than others. The one that comes to mind is the Lantana parking lot land swap, which they took contingent land that was connected to the greater reservation and swapped it so that Lantana's could do a parking lot for land that isn't at all connected to the reservation. The land that we're talking about swapping with them is all land that abuts
Correct.
The park already, the reservation already.
One of the best parts about this particular project, in my opinion, obviously the biggest goal is to provide for additional burial needs for the people of Quincy. If you've been to Pine Hill Cemetery, it's in Ward 4, you've been there many times. One obvious thing that you notice is that there are not a lot of trees there.
Right.
It's fairly kind of barren. The area into which we are expanding, we propose to expand, is heavily treed, if you will. So we hope to capitalize on the natural beauty that is there to make the nicest part of Pine Hill Cemetery be the newest part. And you wouldn't necessarily think that that would be the case with cemeteries. Oftentimes, Mo Wollaston, if someone were to visit there, you'd say, look at all the oldest stuff first because it's the most impressive. The goal here would be to create the nicest part of the cemetery and have that be the newest. So take advantage of the natural environmental benefits that are.
And we're providing adequate land back to the DCR.
Correct. All of those things that are going to sort of line up and agree to.
And then, lastly, you had spoken about in your pre-presentation that we're offsetting these costs with the sale of the additional plots that we would gain, correct?
I'm sorry.
We're offsetting the cost of the $50,000 expenditure. We're going to recoup when the plots are sold in the expansion area. Is that what you were?
We're always, accruing fees, if you will, through the sale of all of these lots, and that account gets built up over time, whether it's through, this particular one is an account that is funded by the sale of lots. We have other ancillary fees that folks are charged to have a burial. So this fund has been building up, and we draw it down annually for things like this.
Thank you.
Thank you, Councilor Palmachini. Further discussion? Yes, Councilor DeVon.
Thank you, Madam President. These two cemeteries in general, nice to see you, Mr. Cassano, as well. What is the capacity of these, where plots can be still bought? What are the two capacities of each cemetery?
Right now at Mount Wollaston Cemetery, we have 0 plots for sale. Whether it's on an as-needed basis, pre-need, there is nothing for sale there. Right now, we anticipate, based on the demand we've seen in the last few years, that we have the ability to accommodate fairly quickly years for a Pine Hill Cemetery. Obviously, there are tens of thousands of people that are interred at both places, and we're rapidly running out. But we believe, like I said, based on the estimates we have, another 2 to 3 years at Pine Hill, we should be fine.
Okay, that's it. Thank you.
Thank you. Further discussion? All right, seeing none, Mr. Clerk, would you call the roll?
Counsel Kane.
Yes.
Counsel Crowe.
Yes.
Counsel DeBon.
Yes.
Counsel Finn.
Yes.
Counsel LaFors.
Yes.
Counsel Leeang.
Yes.
Counsel Calhoun.
Yes.
President Hughes.
Yes.
8 members.
Thank you. Have a good night.
Thank you, Mr. Casano. Mr. Clerk?
Next item, Madam President, number 4. Nomination election by the Quincy City Council of a clerk committee for the 2016 and 2017 council sessions.
All right. Thank you, Mr. Clerk. Chair recognizes Mr. Kane, Councilor Kane.
Thank you, Madam President. While I've only had the short opportunity to work with Jen Manning thus far with the current clerk of committees, I seek to nominate her for this role once again. I know that she's been quite influential, at least in my coming up to speed, and an invaluable asset to this council. I know that we will continue to benefit from her organization and her institutional knowledge.
Is there a second? Yes.
Yes.
Councilor Calhoun.
It's my pleasure to second the nomination of Jennifer Manning. She has been, without a doubt, a breath of fresh air in her attention to detail and her focus on this position. She has been not only a pleasure to work with, but she has proven herself to be extremely capable at the job to which she has been appointed previously, and I think certainly suitable to continue with that job as we look forward to working with her. I'm done.
Thank you, Councilor Calhoun. Thank you. Any other nominations?
Motion to close nominations.
All right, seeing none, motion to close nominations. Motion, second? Second. All right, seconded. All those in favor, close nominations? Aye. Okay. Mr. Clerk, will you call the roll, please?
Necessary to name the candidate for clerk committees. Counsel Kane.
Jen Manning.
Counsel Crowe.
Jennifer Manning.
Counsel DeBon.
Jennifer Manning.
Counsel Finn.
Jennifer Manning.
Counsel LaFors.
Jennifer Manning.
Counsel Leeang.
Jennifer Manning.
Counsel Calhoun.
Jennifer Manning.
President Hughes.
Jennifer Manning. Congratulations, Jen. Thank you. All right, she'll be sworn in tomorrow morning. Very well. We'll post it on Facebook. All right, next item.
Next item on the agenda, adoption of the rules of the city council as amended, adoption of rules of the city council of 2015 as amended to be the rules of the city council for the year 2016.
All right, is there a motion?
So moved.
Council Calhoun, is there a second?
Second.
Okay. Any discussion? Seeing none, Mr. Clerk?
On the rules, Counsel Kane.
Yes.
Counsel Crowe.
Yes.
Counsel DeBon.
Yes.
Counsel Finn.
Yes.
Counsel LaFors. Counsel Leeang.
Yes.
Counsel Calhoun.
Yes.
President Hughes.
Yes.
8 members, the rules are adopted, will be reprinted.
Next item?
Next item, authorize the city clerk to print a list of items pending before the city council after each meeting, known as the calendar. We're going to go into the calendar system very soon. This council will be receiving very soon. Necessary to adopt.
All right. Is there a motion?
So moved.
Is there a second? Discussion on the motion? Seeing none, Mr. Clerk? Please call the roll.
On the calendar, Counsel Kane.
Yes.
Counsel Crowe. Counsel DeBon.
Yes.
Counsel Finn.
Yes.
Counsel LaFors.
Yes.
Counsel Leeang.
Yes.
Counsel Calhoun.
Yes.
President Hughes.
Yes.
8 members. Calendar is adopted. Next item, Council Order 2016-008, adoption of the 2016 City Council meeting schedule that has been presented to everyone. It can change, but it seldom does, but due to special occurrences, it may change. We usually adopt it the first business meeting.
All right, thank you. Motion by Councilor Calhoun, seconded by Councilor Kane. Discussion? Seeing none, Mr. Clerk?
On council dates for the year 2016, Council Kane.
Yes.
Council Crowe.
Yes.
Council DeBon.
Yes.
Council Finn.
Yes.
Council LaFors.
Yes.
Council Leeang.
Yes.
Council Calhoun.
Yes.
President Hughes.
Yes.
8 members, the order is adopted. Next item, Madam President, is Council Order 2016-009, that the city clerk be directed to cause notice to be given that the meeting of the citizens of Quincy qualified to vote in primaries shall be held on Tuesday, March 1st, 2016, in the several polling places herein designated by this council, that each such citizen may on that day, in the several precincts in which they are entitled to vote, give their voices. This is the presidential primary, Democrat vote, and United Independent Party necessary to call the election.
All right, is there a motion?
So moved.
All right, is there a second? Discussion on the motion? Seeing none, Mr. Clerk?
Council Kane.
Yes.
Council Crowe.
Yes.
Council DeBon.
Yes.
Council Finn. Council LaFleur. Council Leeang.
Yes.
Council Calhoun.
Yes.
President Hughes.
Yes.
Orders adopted. Second part of this order. March 1st, 2016 presidential election polling places. Necessary to name 30 polling places. Same polling places as the November 2015 city election. Wards 1, 2, 3, 4, and 5. Polling places for the March special, presidential election. President Booker.
All right, motion made, seconded by Councilor Kane. Discussion on the motion? Seeing none, Mr. Clerk?
On designation of polling places for the presidential primary, Council Kane.
Yes.
Council Crowe.
Yes.
Council DeBon.
Yes.
Council Finn.
Yes.
Council LaFleur. Council
Yes.
Leeang.
Yes.
Council Calhoun.
Yes.
Council Hughes.
Yes.
Next order of business, 2016 0011, call of an election for a special election for Quincy Ward 6 City Council seat. As you know, the untimely and tragic death of our colleague, Council Brian McNamee, necessitates that the city clerk be directed to cause notice to be given to the meetings of the citizens of Quincy Ward 6 qualified to vote in the preliminary. Will be held on August 5th, 2016, in the several polling places herein designated by the council, and all such citizens on that day in the several precincts which they are entitled to vote, give their votes for the election of a candidate in preliminary for the following office: Ward 6 City Council. Necessary to designate April 5th and May 3rd as the final date for a special election to fill the vacated seat in Ward 6.
Okay, thank you, Mr. Clerk. So there's a motion, is there a second? Is there a second? Okay, motion's been made and seconded by Councilor Kane. Yes. Yes, Councilor Finn.
Excuse me. If I could we ask Mr. Tenants to come forward to address this specifically?
Of course. Solicitor Timmons.
Thank you, Mr. Timmons. You are aware, obviously, you've received an opinion from Mr. McRitchie, who's representing Mr. Harris, related to the Ward 6, the call for a special election. And if we could, I think it's important that we get out here, given the fact the number of questions that are out there. As we know, people are already beginning to think about running for that office and the like. And Mr. Harris is laying claim based, according to the Chapter 321, the act that still governs these in relation to this. And I was wondering if you could walk us through your opinion as to why you believe there's a need for a special election.
Certainly. Good evening, members of the council, Madam President. I have read both opinions, both an initial and then a revised opinion of Attorney McRitchie, whom most of you may know has extensive experience both as a former city solicitor and assistant solicitor, and has worked in the office that I now hold. In this particular instance, though, he's representing Mr. Harris, who's a particular candidate whom everyone knows ran in the fall, finished second at Brian McNamee. Mr. McRitchie's put forth an opinion that relies primarily on a special act from 1953, Special acts are something akin to ordinances at the municipal level. They're enacted by the state legislature. And this particular special act regulated what was to go on in Quincy as of the date it took effect back in 1953 in regard to situations such as the one we encounter here. However, a number of things have happened since 1953 that have altered the playing field. First of all, there was a city charter enacted here in Quincy that had particular provisions. That occurred, I'm not exactly certain of the date, 56 or 57, but it postdated 53. The city charter had provisions within it about what was to happen if a vacancy occurred in the office of the city council. But more particularly moving forward, in 1984, and then again in 2004, there were two specific actions that occurred, initiated in the body of the city council. In 1984, the Quincy City Council passed an ordinance, and it was a home rule nature. It was sent up to the legislature, and the legislature subsequently enacted a special act that said that if there is a vacancy in the office of the city council during the first year, then there's to be a special election called. I'm paraphrasing here. So essentially in 1984, what the city council did, and the legislature backed it up, was said that if a vacancy occurs during the first year, unlike the 1953 Act, then the city clerk is to call a special election, and the vacancy is to be filled by the electorate. In 2004, the city council again revisited the issue. This time, they kind of made a more nuanced change. What they did in 2004 was they limited the call for special election to the ward council position only. So if a vacancy occurs in the office of a ward councilor, as of 2004, if a vacancy occurs during the first year, then the city clerk is to call a special election. And that's what he's doing tonight. Now, the nature of the discussion that has been prompted by Mr. Harris and his attorney, Mr. McRitchie, and I certainly understand it, is that just a few short months ago, we put a lot of time and energy into running for the office. And he finished as the runner-up. And under the acts of 1953, that would position him for an appointment by this body. However, as I've indicated, the city council first in 84 and then again in 2004 specifically ruled, or through ordinance, and it was backed up by the legislature, who subsequently enacted a concomitant, they call it special act. What has happened is the electorate gets to pick the successor, not this body, if the vacancy occurs during the first year. Now, Mr. McRitchie and I have had one discussion, a fairly, well, it didn't have to be lengthy, but it was, we certainly covered the issues. Mr. McRitchie is of a mindset that the word occurs has more meaning than I attribute to it.
Could you repeat that, please?
Pardon me?
Could you repeat that statement?
Mr. McRitchie is of the opinion, and part of the basis for the opinion that he has submitted is that the word occurs that appears in both the ordinance and the special act is of a different meaning than the meaning I attribute to it. I believe that the language says, and I'm quoting now, I haven't been, I'm trying to give you an overview, but the specific language says, if a vacancy occurs in a ward councilor position of the city council of the city of Quincy for any cause during the first year. So if the vacancy occurs during the first year for any cause, and if you back up, and I know I provided copies already of the special act to the clerk, and I believe has provided them to each of you. But if you look at the language of the special act in 2004, it says notwithstanding the provisions of any general or special law to the contrary. So essentially what first the city council did and then the legislature did is they said notwithstanding anything else that exists prior in time, we're saying that these are the rules you can follow going forward. And it's very broad sweeping and encompassing language. It says that if there's a vacancy in the position for any cause, and so it doesn't get into the type of distinctions that occurred back in 1953. Now, I'm only speculating here, but the potential reasons why that language was modified are numerous. One is, why would you have a special election if someone passed away in office or refused to take a position versus another set of circumstances later on? What the special acts in 84 and 2004 have done is they've taken away any sort of discretion which could lead to challenges that the body's acted arbitrarily. It says you analyze the time frame when the vacancy occurs. First year, special election; second year, an appointment process. This one is clearly a first year vacancy, and therefore it's to go to the electorate to determine the vacancy.
One question was, the opinion that you wrote back in 2011 related to replacing Councilor Monday at that particular time. But you reference the Acts 321, the Acts of 1953. You note that it's never been specifically repealed, modified, or superseded. And it's in fact referenced in the 1984 modification legislation, indicating that both the Council and the legislature recognized its continued applicability at the time. Here's the one question that I have. I think I understand what's being said here, is that in one hand we have a vacancy that occurs within a particular person's term, beginning, in this case, January 4th. But if you look at Chapter 321, again, there's another provision in there that refers to a failure to elect, or that it says a failure to elect a city councilor in a minute, or if a person elected city councilor, such an election resigns or dies before taking the office, the city clerk shall, as soon as conveniently may be after the remaining city councilors elect to take office, notify the city council of such failure to elect, resignation or death, and within 15 days after councilor for the unexpired term, whichever of the defeated candidates for the office of city councilor at such election are eligible and willing to serve, receive the highest number of votes, etc., etc. But so that seems that what their argument they're making is that although true, 1984 overturns how we handle a vacancy that occurs within that specific period of time, it doesn't apply necessarily to what happens to someone who dies or resigns between the election time and actually taking office. Are you suggesting that it does
Yes.
override that?
Yeah, it clearly does. It says if a vacancy occurs for any cause. So in 84, that was the first time the council visited. They decided, if you look at the special act of 1953, it's much lengthier. There's a lot of drop-down menus in that special act. Well, in reviewing it all in 1984, they made things very simple. They just said for any cause. Keep in mind, the death of Councilor McNamee is the cause of the vacancy. The vacancy is occurring, was no concern until his body convened and the office was vacant. So it's occurred during the first year. I know that the cause is the death of Councilor McNamee, that the cause occurred prior to January whatever date. But the fact of the matter is, until his body lawfully convened as a body, the question of whether a vacancy existed, or I should say the question of whether a vacancy occurs in a ward council position didn't exist. It exists once you convene as a body. And,
For that specific term. For
correct,
the
yes, yeah, for this term. Right. I think that the significance of the language for any cause during the first 12 months is very important and is what carries the day here.
Well, the problem, and I'm just, again, struggling with it, but the problem I have with that is that same language from any cause actually is applicable in the 1953 Act, or 321. It states the same thing. So it clearly then moves on to a different set of circumstances, which it seems not to be applying to a vacancy that occurs during a term, but what happens when there is a failure to elect or a failure for a person to take office. And it seems that they outline two separate and different types of provisions. And so that's where I just, and again, part of the reason for the importance of this, I think it's important to know, is that, you know, no one has any horse in this race, so to speak. There's no grand conspiracies. All my major concern is making certain that we're applying the law and appropriately. And one of my concerns is if we have a situation now where we're being asked this evening to set a special election, and if they go to seek declaratory judgment of some sort after that, then people will have gone out and laid out specific expense to start their campaigns or to run if we don't have, again, some sense or understanding of whether we're right or wrong in this. Do you understand where I'm coming from on that?
Well, I do, I certainly do, but, you know, the way things work, I've reviewed it, I've asked others to review it, I've reviewed what Councilman McRitchie has submitted, and it seems pretty clear what was going on here, that it was the intention of prior city councils and the state legislature when they modified the language to say, look, irrespective of how the vacancy occurs, if it's a first-year vacancy, then it goes back to the electorate. And there's wisdom to that is as simple and compelling as the wisdom that Mr. Harris might put forth in support of his position. I mean, the fact of the matter is there are people here this evening who I know have expressed an intent to run for the office. They perhaps, had they known that Councilor McNamee, had he had the luxury of choosing not to run, as opposed to undergoing the circumstances he did, then perhaps these folks would have put forth their names on the ballot. So there's that dynamic in play, and then there's all the compelling reasons that Mr. Harris might raise. But the law is pretty clear and simple, and I think it's broad language. We saw back in 1984 that the legislature struck some language where the city council put in a more particular provision about Chapter 58 shouldn't apply to Quincy. The legislature struck that because they're saying, look, we already have broad sweeping language here. We start dropping in particular provisions and we miss one, then that leaves you open to the type of interpretive scenario that you are now concerned about. I think that the fact the legislature in 1984 struck the language about Section 58 submitted by the city council is very significant. It shows an intention for the type of broad language and broad application. And in the balancing test, it's a simple test of first year goes back to the electorate, second year we handle it through the council point. And my reference to the Acts of 53, back when Councilor Ramondi's position in Ward 2 became vacant, was more particularly to provide guidance about 53 does have some particular provisions that gave guidance to the council about whom they should select, that it should be someone from the ward. And those provisions weren't terribly inconsistent from anything else that was suggested. But it's the big thing with Councilor Ramondi, that makes the 2011 opinion irrelevant to this consideration is that in 2011, that was a final 6 months of the term, that vacancy. So I use that language to provide you some guidance, but
Well, I think
you
that,
can argue
that
over
opinion,
time.
I think the opinion was on target, quite honestly, at that particular point in time, so I'm not, I guess the point that I was asking is if there's two separate provisions under 321 that outline different sets of circumstances, you're stating the opinion that essentially this act of 2004 basically overturns what it refers to in the event of death or a failure to elect. That's your
Pretty clearly trumped, yes, because it says for any cause. It's very broad language, and the purpose is that council and the state legislature placed an emphasis on when it occurs, when the vacancy occurs, and whether it should be returned to the electorate, the question of filling the vacancy. So
If we set this election to see in reliance on your opinion, that in no way impedes Mr. Harris from seeking relief.
correct, right. The remedy here really is, I mean, again, if you don't set, then perhaps one or more of the potential candidates will go into court and seek an order that you do set. So I think you have very clear direction from the city solicitor, which under the charter means, I'm your counsel, I'm providing you direction here, and I think you should follow it. If a particular individual has a problem, they do have a remedy. They could go to Norfolk Superior Court for a declaratory judgment. We've been through that type of thing before. It can be done on an accelerated basis given the nature of the question here. And, we could handle it in that manner, that would be fine. But I think that for purposes of this body, that there's a path that I believe you should follow. I'm recommending you follow it. And it's a direct path for this body. You don't get involved in litigation, although you may be nominal defendants in a case like that. Really, once you set the date, which is all you're setting, the process of the election is turned over to the office of the city clerk. So that office would be the party to the action. I would say you couldn't move forward until the court ruled on it. Frankly, it would be terrific in a lot of ways if Mr. Harris were right. It would save us money. It would save Clerk Shea and his staff on the south side of the hallway a lot of time and energy. And, that would be a good outcome, except probably in the minds of some of the folks who are thinking of running. And I think the balancing test and some of the issues that are being talked about tonight have already been addressed by prior councils in the legislature. And that what's left of this council is to set the date. And if someone wants to challenge it, they can move forward and do so.
Becomes very difficult in this setting, obviously, for us to adjudicate the matter. I suppose we can decide for ourselves in terms of how we would vote for this. But I do know that the intent, it was one of the concerns in terms of 2004, obviously, is that we've had a number of elections where there have been folks who have ran that were less than serious. So it was put that way in terms of what they were doing, where in many cases they would have been that second automatic placement. I know that that's what gauged a lot of the thought. So it makes it particularly difficult when you have a solid person such as Mr. Harris in this particular situation. But as for myself, I have to admit that I'm kind of stumped in terms of the applicability as it relates here to Chapter 321. Because it does seem to me that if we're talking about a vacancy, it's one thing. Councilor McNamee did not die in the midst of his term. He died in his previous term. His previous term before and after an election. But if you're saying that you believe that, in your opinion, that the 1984 also includes that particular provision, that's your opinion, then, I don't know where to go from there.
Well, I think it's the plain language of the statute. If you agree with me that the reason the Ward 6 council seat is vacant today is because Councilor McNamee died, that that's the cause of the vacancy, then the language of the special act makes it clear that the vote occurs during the first year if there's a vacancy for any cause. I think that the fact, the timing of the death and all of that, it's all taken off the table by the language for any cause. You raise an excellent point, probably accidentally, but I alluded to this. Well, the reason I say it is this. If we get into weighing and measuring, is this like a legitimate candidate or a foil or someone who doesn't belong in public office, so we're going to call a special election. That's the type of discretionary action that's been removed by this broad language. And it's broad, it's clear, and it's very simple. It focuses on the timing of when the vacancy occurs, not the cause of it or who the runner-up is. And back in 1953, you do start looking at those things. So, while I understand, and Councilman McRitchie certainly has submitted a very well-reasoned opinion, essentially what he did was he reasoned from 53 forward, and I started in 2004, because that special act is very clear. It says, notwithstanding the provisions of any special or general act to the contrary, which wipes out everything before. Well, what do you do if all that's wiped out? If a vacancy occurs during the first year of the term, which it has, for any cause, it happens to be the death of Brian McNamee in December, not post-January, or not post-convening of this body. For any cause, there exists a vacancy and it should be filled by a special election. That's the first.
With fairness to Mr. McRitchie, I don't think he's starting from 53 and working forward. I think what he's saying is that the Act of 1953 is still applicable, which again you've acknowledged in other opinions as well.
Right,
That's
in part because of how I worked. Once I saw the language in 04, I was kind of done. But Paul Hines, I gave it independently to both Paul Hines and Janet Peckett and asked them to look at it and asked for independent opinions back. And one of the things Paul Hines pointed out is that we need to look a little more carefully about whether the enactment of the city charter didn't eliminate from any consideration this special act of 1953. Because in the city charter, I think it's section 11, it's one of the early sections, it says that any special acts, any prior special acts, anything else relative to the city of Quincy wiped out and now the charter governs. It does get into language about anything to the contrary. See, that's where I did reach back in the Ward 2 matter to give you some guidance about how to select to some particular language. But I think it's pretty clear here that the for any cause clause extinguishes the provisions of the Acts of 53 that Mr. McRitchie is relying on.
See, that's where and again, we'll start going in circles very shortly here, but the from any cause language exists in the chapter 3.
It does what?
It exists. I mean, it's the opening, it's the first.
What do you mean, that language is used in the act?
It says that if at any time a vacancy occurs in the city council in the city of Quincy from any cause, the city clerk then goes through. But the assumption under, it seems to me, on the face of it, is that that's talking about a vacancy that occurs during the vacancy of the specific term. And that is referring to any cause. And then later, it then begins to address failure to elect, which includes death, resignation. So to put it very simply, I mean, at the risk of sounding crass, and I don't wish to, but different things apply for a person who dies prior to assuming office in January 4th, and for the person who were to die after January. That there's two specific different things that it seems to call for. So it's hard for me to see how just add the language from any cause eliminates that specific provision.
Well, how is death not a cause of vacancy, other than the cause of vacancy?
Well, again, we're getting into semantics of this, and I don't want to be, I clearly don't want to adjudicate the matter specifically here either, and I want to rely on your opinion. But I think what's being suggested is we're noting what the definition of vacancy as opposed to the definition of failure to lapse. There's two separate things.
Why do you not get into his semantics, get into mine?
Well, other than that, fine.
Again, it's not a question of semantics, it's just a question of interpretation. Mr. McRitchie's been very thorough, and I understand precisely what he says. I think he understands what I say, and we disagree. If we got 5 more lawyers in here, if each of the candidates brought in their own lawyers, there'd be nuanced opinions. I do understand your question, but I think that the death is what is somewhat irrelevant. I think in 1984, the legislature did not make the same mistake that was made in 53, which was, you recall I mentioned that in 1984, the city council set up an ordinance that said Section 58 doesn't apply, and the legislature just struck it. They said we already have this notwithstanding language, so it's out. But it is interesting, and it's one of the reasons lawyers end up looking like this later in life. Don't continue to look like they started out, but we disagree. But I happen to be the holder now of the office of city solicitor. I think I have a solid opinion. If Mr. Harris disagrees, I would invite the challenge, not in a defiant way, but in a very collegial way. I mean, there were many of us who, in some respects, from the perspective of the operation of government, it's better if it's right, because it's an easier outcome. From the taxpayer perspective, it's better if it's right. But from the electorate perspective, it's not better if it's right, because now this body is filling an office that should be filled by the voters, according to the language here, and the minds, I'm sure, of many of the voters and the candidates who believe that they should have a voice where this is a first-year vacancy. So it's a very interesting question, but I respectfully think the answer is pretty clear. But I understand why there's a lack of clarity getting to the end zone.
Thank you, Mr. James.
Thank you. Recognize Councilor Conrad.
Thank you. I have to, just at the outset, wonder what my former colleague from Ward 6 would have said to this discussion tonight. Probably some sort of witty one-liner. But I just, I haven't spoken publicly about Brian's passing, and I just, before we get into this, I'm going to ask you some questions, Jim. I kind of want to wax philosophical a little bit, but don't go anywhere, it won't be long. We didn't really get along too much, too well, but I will miss his one-liners, his witty one-liners, probably the majority of which were directed at me or some sort of policy position that I stood for. The remainder probably were directed at Kevin Coughlin, as we were the target of much of his waxing philosophical. But I'll certainly miss him leaving meetings as we were wrapping up, wheeling his little piece of luggage that he carried his council work in. I developed Pavlovian response to seeing him in his little wheelie leaving the meeting. I know that it was over, and I get excited that I get to go home.
It's like red on back lighting up a cigar.
Exactly. And it'll be sad tonight when we're scheduling committee meetings and I don't see him shaking his head, wheeling his wheelie away. But he'll certainly sorely be missed by this body. So, that being said, I mean, I'm not going to do a McNamee impersonation, but I trust any questions he would have had if you would have started with, Jim, come on. Tell me how it's going to be. And I've reviewed the letter from Mr. McRitchie, from Attorney McRitchie. I reviewed your opinion, the material you sent us, and then I also reached out to the clerk, and I don't know if he had provided them to you. I suspect he probably did, but I asked for meeting minutes from the 2004 meeting of the council and the 1984 meeting of the council. And I have both those orders that you've referenced tonight. Have you seen those? You have a copy of those?
Yes. Assistant City Clerk, Crispo was kind enough to assist me with that.
All right. And so I've reviewed those, and you and I thank you for your time on the phone the other day when we went over this as being a lawyer by trade. I'm naturally inquisitive when I get a letter from a lawyer about something that I'm then going to act on. So I appreciate you taking the time and walking through this with me. I just want to ask you a couple of kind of quick questions and then get into the meat of it a little bit. Actually, first, let me ask Clerk Shea. Joe, do we know how much this special election, if approved by this body, will cost the taxpayers, approximately?
It costs, on the low side, 13,000, on the high side, 17 or 18. Some things, it's the personal service cost, police and election workers is much reduced. But certain other things, advertising, etc., cost the same, whether they're advertising for one ward or the whole city. Printing is, of the notice and everything's pretty much the same. So I would settle on 15,000. I hope to keep it at that. It is what it is. It's the bilingual ballot is, which we now have, and we will have on the next millennium, 100 years, I hope. It's costing more, but what are you going to do? It's probably not 20, but it's more than 13 or 14.
Thank you. And I take my fiduciary obligations to the taxpayers of the city of Quincy very seriously, even when we're talking about amounts in the range of $15,000, and I don't think that that's an expense that, or an endeavor of having a special election is something that this body, or the city, certainly not this councilor, takes lightly. If there is, as a member of a legislative body, I think we have to follow the rule of law. I think that there has to be some deference given to the councilors who came before us, who sat in this body, sat in this chamber in 2004, 1984, who have debated this as a policy for our city previously. I think that we have to give some deference to them, that while I applaud Mr. Harris's enthusiasm to serve, I think I may disagree with his legal interpretation. Just for the record, I note that Mr. Harris is here this evening in the audience with his attorney. I see two other individuals, Mr. Knowles and Mr. Riddell, out there as well. And I hope that should this body support calling for the special election, that he brings that same, Mr. Harris brings that same eagerness to serve to the campaign for the open seat. But let me ask you, Jim, first of all, it was raised by Councilor Finn that Mr. Harris may seek a declaratory judgment or some sort of relief, depending on what this body does tonight. I mean, legally speaking, he could have already sought a declaratory judgment, knowing what your opinion is, right? I mean, we don't necessarily have to set the election. Once we set the election, that gives them a cause of action beyond declaratory relief, but to actually stop the...
Yes, I would call the setting of the election by this body more of a step along the way than a matter of process that needed to be stopped or reacted to.
Right, so it's not that the vote by this body, if we were to set the special election, may be an encouraging step in the process for Mr. Harris to bring his legal claim to court to be decided by a judge, but it's not the triggering event. He could have done that yesterday. He could have done that today. Well, yesterday was a holiday, but he could have done that today, correct?
Sir, yes.
No, you also could have done that, correct? You could have sought a declaratory judgment?
Well, not really. I mean, I have the luxury of being the city solicitor, and I'm a little, perhaps overly deferential, but that's because of the mayor I serve. In some communities, the city solicitors issue what they call rulings and say, that's my ruling, and that's how folks have to act. And when you read the charter, it somewhat leaves it a bit open, but I would not, in a situation like this, file a declaratory judgment. Because if I were to do it, I'd be inviting all kinds of, I would say, responses by others who, you're probably familiar, but others would be of the term mandamus. It's almost an abdication of my responsibility. I've analyzed it, made a decision, and given advice. I don't need to go to a court and ask for a third-party opinion. And that's not arrogance or anything. I'm just saying that's my role. I've performed the function, and now if a party disagrees, they can seek declaratory relief. So technically you're correct, but I would say, that's not a proper way for me to perform my job.
Thank you for that explanation. Now let me ask you, what is the legal requirement, if you know, of this body to call for the special election? Me as a city council, what's my legal obligation to call for a special election? Hypothetical, what if this body doesn't want to do it? What if we say no? What if we just, someone objects, thing goes on to another agenda, it doesn't happen, for whatever reason it gets kicked down the road? I mean, I think that's unfair to the residents of Ward 6, but I'm just, in a hypothetical sense, what's our legal obligation to actually set the date?
Well, the way the special act's written, the Act of 2004, the language says, shall forthwith call a special election. So it's not discretionary, it's not a matter, it's a mandate that you forthwith call a special election. There is now a vacancy. Ward 6 requires representation. The citizens of Ward 6 require representation. So it's incumbent on this body, under the provisions of this special act, to forthwith call a special election, and I would call that a mandate.
And there's no specific time frame from the date of the vacancy to the calling of the election?
Correct. It says forthwith, which means you should act in due haste. And I know that the city clerk, the assistant city clerk, and I have talked on several occasions about timing and everything. And the city clerk has made an earnest effort, I would say, by the first meeting after an election cycle, getting the matter before the body. So that meets the mandate of forthwith, I would say.
That's if we were to pass it tonight, if we were to vote in favor of it tonight, but if we weren't, if we were to delay, would you suggest that would be this body not acting forthwith?
Correct.
So then essentially it's your legal opinion that the body not only has the legal authorization to call for the special election, but we also must call for the special election tonight.
Well, I'm saying the language here says shall forthwith call a special election.
Two legal opinions that we can call a special election, and that's the appropriate next step to fill the vacancy. Right? Your interpretation of the law is that to fill the vacancy, we need to call for a special election, and then your interpretation of forthwith, the time frame to call that special election is tonight. So that's, you're not giving us a lot of room. I'm not complaining about it. I'm just, for the record, that's, we have to call for the election, the special election this evening. That's your legal opinion as the city solicitor.
Right, that's a different question than has ever been proffered to me, and we're in a little different part of the act. But yeah, the last phrase is shall forthwith call a special election.
Now, this is something separate and apart from what we're facing tonight. This is an issue or a policy that this body could attempt to affect change, right? If this body, the 8 folks sitting up here, if we decided that it makes more sense to appoint the runner-up given any vacancy, we could do that, correct? No, not tonight going backward, but we could do that either through a home rule petition, right?
Right, I don't think it would apply to the current Ward 6 vacancy, but you could go back, someone could bring forth a new proposed home rule petition, and you could go through the process of trying to get that passed, and that would be available, I would say, when the next.
And that same process of bringing forward a home rule petition has been available to this body since the last time this body, the council, has addressed this issue in 2004, correct? So for the past 12 years, that has been an option for policymakers to enact a different policy of how to handle a vacancy, right?
Correct.
And there's nothing we could do, this body now, moving forward, that would change the conditions of the vacancy, the current vacancy in Ward 6, or not change conditions, but change the reaction to the vacancy.
Well, that's correct,
I mean,
yes.
we couldn't say timeout in the special election. We actually want to go file a home rule petition. I introduced tonight. Home rule petition, we appoint the runner-up, and then we wait for the legislature to act, and then we appoint the runner-up in the last election. That'd be ex post facto.
Right, and ex post facto law, you'd have one or more of the candidates filing a challenge. You might have 10 taxpayers. It would create a maelstrom, I think, of activity.
Ill-advised is, in your opinion.
Yes, correct.
Now, what about, mildly off topic, but still related? I've expressed the concern privately to folks that I think ward council seats are too busy and they're too important in the impact that they have and the interactions that they have with residents on an everyday basis to be vacant for any meaningful length of time. I think that even scheduling this election in a couple of months, that's too much time to have this seat vacant. I understand that it's also your interpretation that this body cannot vote to, at least in the interim, fill that seat, correct?
Right, you could have appointed someone back after the death of Councilor McNamee.
To sit for a week or two.
Right, and at that point in time, there were no scheduled meetings, there was no business really before the council. You were already, there had already been a motion to push all the matters forward into this year that were going to be carried forward. So there was no business before the body, no scheduled meetings, no issues. So therefore, as I understood things, because I know that Councilor Finn, who was the president of that body, engaged very seriously that question. And it wasn't until he was satisfied with the answer that he didn't call, he could have called a special meeting and appointed someone and did not.
And that's not a criticism of any decision that was made. I'm just trying to walk through this thing. But we cannot appoint someone now in the interim to sit in the Ward 6 seat, right?
Correct. With the language of the ordinance says that the remedy is the special election. And I know that if you sought to appoint someone, even if it were along the lines of the important policy objective you're trying to achieve, which is not have a vacant office, that person would have, the right to claim incumbency and the right to do some things to give he or she a foot up in the pending special election. So anyone who didn't get appointed but was interested in the office would challenge that action.
Are you saying we could do it though?
No, I'm discussing why you cannot.
Right.
Yeah, no.
Yeah, that way I didn't think that
Can't
was
do
the
it.
reason. In my head,
That's
I'm
the
thinking,
rationale
oh,
behind this.
I didn't think we could, but based on that's the worst case scenario. But that's something we could change though, moving forward, correct? How would we do that to allow for the appointment of an interim counselor to serve during the period pending a special election?
that'd be a very interesting discussion, just bring it in as a proposed home rule, and there'd be a lot of back and forth, I would imagine. But,
And then, so we propose it as a home rule petition, send it to the legislature for action.
correct.
All right, now, much of the discussion, I almost called it debate, the discussion we had with Councilor Finn, which was essentially a reaction on your part to Attorney Ritchie's position statement.
Talking with Jamie Ritchie, we know things down a bit too. If a vacancy occurs, what does that mean? And when did this vacancy occur? Because it is arguable that because Brian McNamee's death occurred in December of 2015, one might argue that that's when the vacancy occurred. But I'm saying, no, the language of the statute doesn't really look at the action that caused the vacancy. It says, for any cause during the first 12 months of the term. And so,
Any causes you're interpreting, that you're interpreting to include death of.
right, that's where I think that
victim.
the drop-down menu in 53 got wiped out. Rather than going through that type of process, it was just wiped out by this legislation.
And what's the issue relative to vacancy?
Vacancy occurs. I'm saying that once you convene as a body and the members are sworn in, that's when the vacancy occurred. Because there was a body and there was no one here to answer the call, the roll for Ward 6.
And the counter argument to that, if you know it, would be what? I mean, there's a vacant chair right there between.
Well, now I'd be getting too far down the road characterizing things which wouldn't necessarily be fair to Mr. Harris or Mr. Ritchie, but they view it differently, I'll say that much, and it's in writing. It's something you submit.
Now, what's the weight of our interpretation? If we would vote, what, in a legal proceeding, what's the weight of our action this evening on any, if you can speak to it, potential litigation relative to this issue? Is there any weight given to what we?
Well, I think it would certainly, carry weight, whether this legislative body which enacted the ordinance that prompted the special act is going one way or the other on. I think it would carry weight.
Legal case law suggests you have to give words that are everyday, regular, plain meaning. Certainly, I would hope that if an action that we take based on an opinion that you render relative to the call for a special election, that the action we took, essentially interpreting our own body's precedent, would have some weight in the court. So you think that it would, to some degree, be viewed that way by a judge?
Right. I can very comfortably say some weight. I don't know how much, but if challenged, I certainly would raise it. And I'm sure that if you were to act in a manner contrary to the plain language, then I'm certain that that's something that Mr. McRitchie would be waving around. I know that were I in his position, I would.
And can you speak to the risk, if any, there would be, should this body move forward tonight with the matter before us and set the special election date?
Well, there's no risk. It's just an act. You're setting dates, and what it'll essentially do is it'll put everyone on the clock. If Mr. Harris wants to challenge this, he'll have to proceed in court. And when we go to court, we'll indicate these are the dates that have been set, and we'll ask the court to cooperate by expediting things. And this is the type of matter that would probably be handled on a briefing and oral argument basis. There aren't any mysteries here.
And you would expect that to occur quickly should a suit be filed?
Yes, it really would have to.
I mean, because one of my concerns here tonight in voting for this, with this kind of dark legal cloud hanging over it, is what that does primarily to the residents of Ward 6. If there's uncertainty in listen, it's hard enough to get people to vote on an election day, come out and voice, their thoughts and opinions on an election day that's been scheduled for months with a lot of publicity and a lot of candidates and fanfare, but for a special election to be held at an unusual time in a small part of the city, 1/6 of the city. I think it's hard enough to try and encourage people to vote or to expect them to come out and vote in that election, never mind throwing lawsuits into it that would seek to cancel the election and uncertainty in that. So I think that that's a kind of a risk that we would need to consider as to what, if we take that action tonight, what the ramifications are tomorrow and moving forward. I mean, listen, I'm a lawyer too. When people say, we'll sue you, that it really doesn't scare me as much if I think we're on good legal ground. And that's in my day job and in this position as well. If we accept your opinion for what it is, which appears to me to be well-founded on a solid legal basis, the risks are what they are, that someone's going to sue. Someone can sue you for
Yeah, I think the challenge by an individual, or the question, it's not even a challenge that constitutes a legal cloud. I mean, this is what happens in democracy, and there's a little back and forth, that's fine, but I think that doesn't mean we stop and pause and wait. I think that we should just move forward in the process. That's the way we can address some of the issues you raised early on about the fact that Ward 6 is now without representation. And the best thing I respectfully suggest this body to do is move us toward a vote by setting the dates. And then Mr. Harris can make a choice. He can either have heard what the body says and heard the discussion tonight and consider his options, and then he'll either challenge it in court or perhaps participate in the electoral process again, or maybe he'll say, I'm not sure I've got enough. I don't know what'll happen, but I go back to comments earlier that it would be terrific from a taxpayer standpoint and an efficiency standpoint if he were right. But I just think the plain language of a very, short, concise statute is pretty clear, so.
Well, thank you, Ms. Simmons. I appreciate that. And I agree with you. I mean, if we had the luxury of doing the things that were perhaps easiest and in the best interests of perhaps the city financially and procedurally, it would be clearly the truth should be appoint Mr. Harris, allow Ward 6 to be represented or to not go unrepresented for a number of months, save the taxpayers some money. I think that would be the easier course of action. But unfortunately, as a legislative body, it's incumbent upon us to follow not only the law of the state, ordinances of the city, but also to pay deference to, again, those that sat before us and the policy decisions that they made. This is a policy that has gone uninterrupted for 12 years. I've been up here for 6. Councilor Finn, you've been up here the entire 12. I've been up here for 6 of those. I don't recall anyone ever offering a home rule petition to change this. It's pretty clear if you're looking in the the minutes, 1984, and looking at the the council order 2004-16, January 20th, 2004. I can only imagine that it received a robust debate, given that only 6 of the 9 councilors voted in favor of it, 3 of them voted against it. Going back to 1984, it was unanimous. That council approved it on April 5th, or signed by Mayor McCauley, April 5th, 1984, unanimously passed by the council on April 2nd. I mean, these are discussions, these are debates, this is a policy that was rendered by the city council prior to us sitting in these chairs, any of us sitting in these chairs, and I think that we have to pay some deference to that they had a policy decision. They came up with a conclusion in a standard that our community could be guided by, and to not set this special election, I think, flies in the face of precedents from our own body And really, you know, I would find disappointing that we don't rely upon the fact that there were these policy discussions in the past. I think we need to stand behind the policy, and that's your interpretation is that of that policy is that we call for a special election. And given that, I'm going to support calling for the special election. I can say with some confidence here that the 8 of us are no better suited to fill the empty Ward 6 seat than the voters of Ward 6 are in a couple of months in a special election. I don't believe that anybody's entitled to the seat under these circumstances. And I fully support letting the voters of Ward 6 decide who their city councilor is. And I'll support this, the setting of the date. I also have a resolution on essentially saying the same thing, which we probably don't need to get into later on the agenda, because I suspect it's the same issue. I didn't realize that this was going to be on the agenda this evening when I drafted that resolution, but I'll speak to that later. But I think we leave it up to the voters, not us, to select their representative to sit among us in this body. Thank you, Mr. Jennings. I appreciate it. Thank you, Madam President.
Thank you. Further discussion? Yes. Councilor Finn.
Again, since his opinion has been referenced a number of times, and because ultimately, being up here, I've always felt that this is essentially the house of the people, so to speak. When a person has essentially, for lack of a better term, a petition or an opinion in some respects, oftentimes it's important that they might be heard. And I recognize that this would require the unanimous consent of the body, but again, just so that there's no misunderstandings, what we're really dealing with here is an interpretation of law. Mr. Timmons is our city solicitor, and I'm prepared to rely on his opinion in terms of setting a special election. But it's just not as black and white and simple as we may think it to be. I know I participated in one of those votes in 2004, and I know part of the intent oftentimes was making certain that it wasn't arbitrarily necessarily determined by a person who happened to come in second in an election for very serious reasons at that particular time as well. And so I see that, but there's a difference that has to be made between sometimes, again, what the intent is and also the articulation of that. Because there seems to be a different understanding in terms of what we're talking about with the issue of vacancy as opposed to, again, this failure to elect, which I think is at a minimum worth understanding, if nothing else, so that we know what's here. So I would request with the unanimous consent that we allow Mr. McRitchie, if he could, simply to present what his opinion or understanding of this was and why Mr. Harris is raising this issue.
Okay. So I think that's in the form of a motion, is it? Or is,
It's a request for unanimous consent. If I don't have unanimous consent, it doesn't go anywhere.
right,
I'd ask for a roll, I'll second that and ask for a roll call
okay. Very
vote
well.
on the motion prior to vote, if I could.
Councilor Pellington.
To Mr. Timmons. I'm never, ever going to give you the opportunity to ask a question this way to you again, so do with it what you will. What do you think of the motion that was just offered? And how would you advise me to vote on it?
Well, I'm going to demur on that one. I mean, it's up to the body how you handle things. You know, I'm certainly willing to hear what Mr. McRitchie has to say. I think in regard to this body, it is really not relevant. I think that the ruling of the city solicitor is the ruling of the city solicitor, and that, you know, inviting other opinions, that's really up to the body. But if the body wishes to hear before it makes a final decision, then you should do it. And he's been good enough to come this evening, and he's shared his opinions as well prior to bringing the issue forth. There have been written opinions that have been shared, and discussions occurred between Mr. McRitchie and I, but I would not presume to advise you on this question. This is definitely a discretionary matter.
I've gone on and on about deference to those who sat in the chamber before me. There's nobody in the current council who sat in the chamber longer than Councilor Finn, so I'd be inclined to defer on his motion and be supportive of it to allow Mr. McRitchie to speak, but I wouldn't do so if you felt that that would somehow any legal position that you would take on behalf of this body moving forward.
Well, I've made pretty clear, I hope and believe, what my thoughts are and what my recommendation is, and I think we should move forward. Now, having said that, you can either listen to Mr. McRitchie or not. You can give it whatever weight you wish to give his thoughts, but I'll just say to you that he's representing someone. He has an obligation to zealously represent the person. He's going to provide you an opinion that is in Mr. Harris' interest, and I provided you my analysis of what I think the ordinance says and how I got to it. And so, you can do whatever you wish, and that's up to you. Now, there are other candidates who came tonight showing the same sense of initiative, who may have brought attorneys that they would wanted you to hear from. They may ask to speak. I don't know. It's up to the body how much you open this up.
And so, my last question for you. We are not adjudicating a legal dispute this evening, right? So it's not one lawyer versus the other lawyer. We act as judges and fact finders and determine which legal argument we wish to support. Your legal opinion comes with it the weight of our legal obligation. I mean, that's why I asked you those questions. Your legal opinion is that we have to call for a special election. Your subsidiary legal opinion that the law requires us to act forthwith leaves us with no choice, based on your legal opinions, but to call for a special election tonight. So it's not as if we allow Mr. McRitchie to speak tonight. We are overwhelmed with his, with his legal prowess and say, wow, he's got a great point. Still, based on your legal opinion and the fact that you are the solicitor, in making that legal opinion essentially binds us to an action that you indicate we must take this, right?
Right. It's not up to you to resolve this question. You're absolutely correct. You're a legislative body acting in a legislative capacity with a specific mandate in front of you, which is forthwith call for a special election. This is in front of you because the city solicitor has reviewed the matter and the city clerk has taken a certain action. So it's really your legislative function that's in play here. You're not a permit granting authority, you're not adjudicatory here. You can certainly hear Mr. McRitchie if you wish and hear Mr. Harris's opinion, which has been reviewed somewhat by Councilor Finn. But that's to whatever end the body, and each of you now, there's going to be a roll call vote, each of you now make that decision. It's unanimous consent whether you hear it. And if it changes your position, I'll be back up here speaking to you about why I think you really should not go down the road that perhaps you end up going down. I don't know.
But you see no harm with letting us speak.
Pardon me?
You see no harm with letting us Attorney McRitchie speak.
Well, I'm not sure what to think. I agree. I mean, to me, if I were sitting there and as a courtesy, perhaps hear Mr. McRitchie, but I don't know anything else. It's going to take the time of the body. And then at that point, I would move to call for the special election. But someone else here, and I don't know, may feel differently and may get kind of caught up in things. And I'm sure that's the goal of Mr. McRitchie, is to try to perhaps influence things here. Because I'm not sure what other goal he might have,
Thank you. Thank you, Mr. With that being said, I struggle to find the point and purpose of allowing Mr. McRitchie to speak based on the opinions that we have from the city solicitor, but in deference to my colleague, I'll support the motion for unanimous consent to allow him to speak. I just hope we don't go too far afield or too deep into the legalese of this with no real ability of this body to do anything but cast a vote in favor of the special election. So it's out of deference to Councilor Finn, and I'll support the motion.
Thank you. Councilor Crawford.
Jim, I'm sorry to bring you back. I would have spared you the commute. But, I mean, the way that I'm seeing this conversation progress is you're either going to vote to support a special election or you're not going to vote to support a special election. I do appreciate, the attendance of Councilor Ritchie, but, I heard you say that could potentially open up some other folks wanting to speak here this evening that might have some interest in said open seat in Ward 6.
Yes.
I mean, I would foresee this just based on our role in this whole conversation. I don't want to turn this into a candidate's night.
You're hearing from one candidate, Mr. Harris, who ran in November and has a position, while there are other people who have expressed the same interest he had. He ran, everyone has to acknowledge that fact, and you're in against Council McNamee, but perhaps these others will say, if Brian McNamee had said he wasn't running, I would have put my name in. And they'll want to come up here, and if they see you going in a certain direction and influence you, and they should be heard as Mr. Harris is heard. All I'm saying, I'm not trying to either mute or stifle any discussion or voice. That's up to this body, how much you get into this. But your role tonight, my opinion, based on my role as city solicitor, based on the action of our city clerk, the fact this has been put forth on the agenda, is just to follow the language of the special act and forthwith call a special election. And then Mr. Harris's voice will be heard one way or another in a different form, a more public form. But if you care to hear it tonight, then you absolutely should hear it. But that's more a decision of the body, not a matter for me to advise, notwithstanding the artful questions of your colleague here. And I know where he's coming from. He's really trying to be careful about how he proceeds. And I understand that, but it's not really a matter of legal advice.
The question is, are you voting to put forth a special election, or are you not voting to put forth a special election? So outside testimony is completely subjective and at the individual level whether or not you want to hear it, correct?
That's my opinion.
It still stands on the agenda. Do you want a special election or do you not want a special election?
Yes.
Right? Just wanted to avoid overcome, the context of the way the council acted. Thank you.
Anyone else not having previously spoken? Very well. Councilor Finn.
Again, this is a very interesting way to start off your presidency, Madam President. But it's interesting, I think I have already noted the fact that I'm more than willing to rely on the solicitor's opinion and support the call of a special election. But, I've also sat and listened to talk about home rule petitions and about intent and about shaping things. One would think there would be some willingness to wrestle with the complexity of law here, to hear if there is a problem here or if there's a question that needs to be better spelled out in terms of how we deal with these things. I've shared with you, quite honestly, I think even going back, my memory fades at times, but in 2004, I know that there was grave concern over who could come into an election at a specific time in order to run for second, as opposed to truly mount a campaign. But the only issue here this evening is that law. It's not about the gentlemen who are here, or possibly women who are here this evening who might be interested in running, or that this is a platform for their candidacy or an attempt to be heard here. I think it's just simply a courtesy that I'd like to extend to Mr. McRitchie since his opinion, what he has referred to, has been referred to a number of times, just to be able for him to state that here, what that is. That's my only intent, and I understand, I recognize that that requires the consent of the body. So with that, I just don't see it as filled with all these various tigers behind rocks in terms of legal challenges or upsetting other candidates. I have, at this present moment, no horse in that race, whether in either outcome. What I'm really just trying to understand is making certain that we're proceeding appropriately with the law. That's it. And if that needs to be, and I don't want to adjudicate that here. I want to rely on our city solicitor. But if there are things that we need to be considering, we should be. So with that, I will promise to say no more on the matter.
Thank you, Councilor Finn. Anyone else? Seeing no further discussion, Mr. Clerk, you can call the roll.
On the motion of Councilor Finn to allow Attorney Jay McRitchie to speak on this issue, Councilor Kane.
Yes.
Councilor Crowe.
Yes.
Councilor Devon.
Yes.
Councilor Finn.
Yes.
Councilor Farr.
Yes.
Councilor Yang.
Yes.
Councilor Calmucci.
Yes.
President Hughes.
Yes.
Motion passes.
Great. Recognize Mr. McRitchie. Thank you for coming.
Good, thank you, Madam President, members of the council. I certainly appreciate the opportunity to speak briefly, and I will speak briefly. And again, I do thank you for the time. It was stated earlier that I started my analysis with the 1953 Act and worked my way forward. And what I'd like to do tonight is work the other way. And because of one of the issues that Solicitor Timmons has raised, each of the special acts contains language notwithstanding any provisions to the contrary, any general special law, notwithstanding and so forth. What that means is that any prior special act, as long as it doesn't conflict, those provisions would survive. So that in 2004, notwithstanding anything, go back, the 1984 Act would still govern to the extent it doesn't conflict. The 1953 Act would continue to govern to the extent it doesn't conflict with either the 1984 or the 2004 Special Act. I suppose I ought to let the cat out of the bag and reveal to you that I drafted the 1984 Special Act that went before the legislature. It occurred at a time when Ward 1 councilor was resigning, and certainly some of the discussion that took place that night was taking place this evening too. Who are we to choose who should represent Ward 1 and about people in Ward 1? So the legislation was enacted that if there was a vacancy during the term, if a vacancy occurred during the term, there would be a special election in the first 12 months if the vacancy occurred within the first 12 months of the term. I compared very carefully the 1984 and the 2004 special acts, and the only real distinction that I can find is that in the 2004 act, it says the city clerk shall call it a special election. In the 1984, it said the city council would call it a special election. And then there is a second section that says this doesn't apply to council as obliged. The second. But if you go back to the 1953 Act, that is the only act that references what happens if the time between the election and the commencement of the term of office, if the councilor dies. That was enacted in 1953. I'm familiar with what's happened in the city since 1982, but I don't believe there's ever been a case where a councilor-elect passed away after the election and before the commencement of the term of office. Now, after the election last November 3rd, I believe it was, all of the councils that were serving at that time that are sitting here tonight and Councilor McNamee had two designations. They were incumbent city councilors at that time for the 2014 and 2015 term, and they were councilors-elect for the 2016-2017 term. Now, the 2004 Act says if a vacancy occurs if it occurs during the first 12 months of the term of office, which to me, I think is pretty clear. The term of office commences on the first Monday of January with this organizational meeting. The mayor is sworn into office, gives his inauguration speech, and then the term inauguration is commonly used in the city of Quincy. I don't see it in the Plan A or any of the legislation, but everybody calls it an inauguration. So I'll call it an inauguration today. The term of office of the council begins when the council is raised their hand before the city clerk, and they promise to the best of their abilities, carry forth and perform the duties incumbent upon them as city councilors of the city of Quincy. Department heads take the same oath in February every year. I took that oath of office for 20, 22, 21, whatever number of years it was that I worked for the city of Quincy in various capacities. And that's when the term of office begins. And I quoted the sections from chapter 43, which is the plan of government. People commonly refer to it as the city charter. It's not technically a charter, but it's a term of art that everybody uses. It's a plan. Our plan, and it says the municipal year starts at an organizational meeting held on the first Monday of January at 10 o'clock in the forenoon. So that's when the term of office begins. If there's a vacancy from that point forward in the next 12 months, pursuant to the 2004 Act, it has to be a special election. And also in the 1984 Act, that was the same provision. With respect to a council-elect that dies after the election and before the term of office commences, that's addressed in the 1953 Act. No conflict with that provision with the 1984 or the 2004 Act. If the vacancy occurs between the election and the start of the term, the runner-up gets the seat. And it dictates that the city council shall, and shall is a term that is mandatory in nature, within 15 days of being notified of the vacancy by the city clerk, they shall appoint the runner-up, or the person who got the next highest number of votes in the prior election, as the councilor for that term. That was the legislation that was cited as authority for the city council to act when there was a vacancy in 2011, when the city councilor from Ward 2 resigned. If he had resigned in the first 12 months of his office, there would have been a special election. But it was in the second year of office. It didn't conflict with the 1984 or the 2004 Special Act, so it goes reverts back to the 1953 Act. You have 15 days to appoint a successor for the balance of the term. The 1953 Act says you have 15 days to act from being advised, and it says the city clerk shall, as soon as practicable, after the remaining councilors have taken the oath of office, shall inform them of the vacancy, and they shall have 15 days to act. Today's the 15th day. If the city council fails to act, that responsibility reverts to, not reverts, but it goes to the mayor. And it will be the mayor's responsibility to do that. It's my belief that there should not be a special election. It's my belief, and I do not use the word entitled. That's a very poor choice of terminology, and it was picked up by the newspaper, I believe. I don't believe I used the term entitled. I don't believe Mr. Harris used the term entitled. I think the legislation requires the city council shall appoint the person who got the next highest number of votes in the election. And the election was just 2 months ago. Councilman McNamee, unfortunately, was a good friend of mine, as he was with many people in this room. Councilman McNamee passed away in the 2014 to 2015 term. It was 12 days prior to the inauguration. The vacancy did not occur in the 2016 2017 term. So it's not a case of a special election. It's the case of, and again, there's no conflict from the 1953 legislation. That's the only act that talks about what happens between the time of the election and the commencement of the term of office. And that's what should go. And I think that's basically it. There's one other councilor, Solicitor Timmons, did make a comment that there seems to be a school of thought that all special acts are wiped out when a new plan of government is adopted. And I'd like to give you 3 examples in Quincy why that would probably not be a pretty good idea to adopt that. We have a licensing board that was adopted by a 1949 special act of the legislature. And it says the licensing board shall consist of police chief, fire chief, city clerk, building inspector, which is now called the inspector of building, the director of inspection services, and health commissioner. In chapter 138, which is the liquor licensing statute, there's a provision that says in every city there'll be a licensing board and will consist of 3 residents appointed by the mayor as members of the licensing board. And they have to be residents of the community. Now, we have 3 members of the licensing board who are not residents of the community. And I know in the past, somebody has challenged at the ABCC the makeup of the City of Quincy licensing board. Well, if as Mr. Timmons suggested, that there's some thought that all special acts are wiped out when a change in the plan of government is adopted, well, we haven't had a proper licensing board then since 1949. If that's the case. I don't believe that's the case, but he suggested that there's some thought that that would be that should be the case, or it might be the case. I'd also point out that we have 1900 special act in the legislature that establishes the City of Quincy Board of Assessors. We have 3 members. Well, we've had 3 changes of government, or 2 changes of government since 1900. We went to Plan E for about 8 or 10 years in the 50s, and then went back to Plan A in 1957 or 58. Is he saying that we haven't had a proper board of assessors since 1947? I don't think so. And there's also a special act of the legislature from 1880 that authorizes the town of Quincy to establish the Thomas Craner Public Library. Now, in 1888, the city of Quincy became a city. Again, it went to Plan E, went back to Plan A. Does that mean that we don't have a library? Well, I certainly don't think so. So that, these are, 3 examples of, obviously why the special acts that have been adopted in the past do not get wiped out with this changes that's going on. So, with that, I guess that's all I have to say. I think Mr. Harris does have, I'm not going to use the term entitled, but under the provisions of the 1953 Act, I think the City Council shall appoint him as the councilor for the term. And again, it really does come down, if this does end up in court, and that's certainly the decision that hasn't been made, Mr. Harris will be making that decision depending on what action the council takes. But if we do end up before the court, the question really does seem to be, did the vacancy occur when Council McAfee didn't show up for inauguration? When it occurred when he died? And I hate to use the term that way, but the vacancy occurred on December 23rd, 2015, when Ryan McAfee passed away. Yeah, anybody has any questions or I can clarify anything, I'd be glad to. If not, I appreciate it.
Thank you, Mr. McRitchie, and thank you for sticking to, as Councilman noted, the law and really advocating for your position and your legal positions. So thank you very much. I know 2 people want to speak. I do want to just ask a quick question and solicitor, if I may, at this point, just before anybody speaks, regarding our questions of Mr. McRitchie and our statements now. Would they be admissible and could they affect any litigation that would possibly happen as a result of this?
Well, I don't know the answer to that, so out of an abundance of caution, I would say, I would advise that no one say anything, as lawyers do in all instances.
Thank you.
And may I just clarify, all Mr. Timmons said earlier about the city charter, lest we have a concern that there is going to be chaos on Hancock Street tomorrow morning, was that an assistant city solicitor said something to me about the city charter. If you read my opinion, which I've given to Mr. McRitchie, I've given to all of you, I specifically say that Chapter 321, for purposes of this analysis, has not been preempted by the city charter. I didn't get into the question of the whole city charter matter, mostly because of the license board thing and a few other questions, and I didn't think it was before me. I relied on the language of 2004. So I hope there won't be concern. I saw that Clerk Shea was looking to call, get some of his members moving to Quincy here on his cell phone, but you need not tonight, all right? That's a non-issue.
Okay. Thank you. Not having been heard previously, Councilor Forrest.
Thank you, Madam President. Alan's a bit concerned about how my question is then being interpreted, but Solicitor General is free to stop it if you think it should be. So, Mr. Ritchie, thank you. I think you should be on the charter committee if we ever do take up that. You've got a lot of volunteer service with the community. So, two things that you mentioned as referencing councilors who served in the last term and are now here today. You said that, after last fall, there were incumbents who were councilor-elect. I would think that there was possibly, so with Mr. Councilor McNamee passing during December, there was a vacancy in his 2015 term. However, this talks about a vacancy during the current term, which doesn't occur until there are two different terms. That could have been two different people, right? So it wouldn't have been ruled the same because of the rollover. He happened to get reelected.
My point in taking.
So when you reference the inauguration swearing in, that term did not begin from that inauguration until those hands went up.
That's correct. So my point is that the vacancy occurred back in 2015.
Different term.
That's right. That's right. And the special
So
act
that's
in 2004 says if a vacancy occurs within the first 12 months of the term.
Right. Two different terms. Two different
That's right.
vacancies.
So
two different terms, two different vacancies.
That's right. The vacancy occurred. This is the discussion that was tonight. The vacancy occurred. The vacancy did not occur in the first 12 months of the 2016-2017.
So I guess I would be in this position that there was a vacancy into the 2015 term. That term could have expired. You could have had a different candidate.
And
By the time you raise your right hand, that's when your term begins. When that term on inauguration day, that term was vacated on that day because nobody was there in presence.
I would say the vacancy was, and I'll use the Latin term, it's ab initio. It was vacant at the beginning of the term. It did not occur during the first 12 months of the term.
It did, because you're saying the term begins when you raise your right hand. If no one's in that chair to raise that right hand, that seat is then vacated.
That's correct.
At that moment. In that moment, that term does not begin until that moment.
The vacancy occurred.
Thank you. I tend to defer my legal opinions to Council which is, I
But
appreciate
that's the issue. That if we end up before a judge, the issue will be when did the vacancy occur?
Right, so.
And the vacancy was caused by the death of Councilor McNamee. With all due respect to Councilor McNamee. But
the vacancy of 2015 occurred at the death of Councilor McNamee. The vacancy of 2016 occurred when McNamee was not present.
that's right. And
Those are two different.
But
He was then, right?
But the 1933 legislation specifies that if a councilor-elect dies, this is how the vacancy would be filled.
I think we've then gone with simpler language. Solicitor Timmons. That's, I appreciate your time here this evening.
Thank you.
All set, thank you.
Okay. There's a motion to move the question. So let's take
On the motion to move the question.
Sorry, Zoe?
On the motion to move the question.
On the motion, the question cannot be discussed.
Second.
Can be discussed. Okay, very well. Mr. Councilor Calhoun.
I just wanted to make a statement. was going to ask Richie any questions. I wanted to make a statement, very brief statement, so I'll be voting against any questions so that I can have an opportunity to simply make a statement relative to what he said.
Okay, thank you. So, Mr. Clerk, if you could call the roll on.
This is Council Law 2016-011. Okay, if I'm moving the question, all in favor?
Aye.
All opposed? All right, I'll take a roll call, but I'm sorry, I thought it was on.
Sorry.
I'm moving the question, Council Kane.
Yes.
Council Kroll.
Yes.
Council DeBon.
Yes.
Council Finn.
No.
Council LaFleurs.
No.
Council Liang.
No.
I'm sorry.
No.
Thank you. Council Palmucci.
No.
President Hughes.
Yes.
4 to 4, the motion fails.
Council Calhoun.
Thank you. I wish we could give out gold stars here because I think Forrest earned one tonight for her legal analysis of the case. And as did you, Attorney McRitchie, for digging deep with the 1880 reference. Appreciated that. I just wanted to note, first, I respect you and your service to the city. I thank you for that. I value your opinion. While I don't disagree with it, I don't think your beef is with this council and the action that we're going to take tonight. Your legal dispute is with the solicitor's opinion. And I would suspect that when you were the solicitor, you would have advised the council, maybe not the same way that Attorney Timmons did this evening, but to the same effect that we would be bound by the solicitor's opinion. And then lastly, I just want to note in your opening sentence of your January 11th, 2016 letter, where you state you are writing on behalf of William P. Harris, you note that Mr. Harris is entitled to be appointed to that position. I don't support that, and I'll be voting to call for the special election tonight. Thank you.
Thank you, Council Calhoun. Further discussion? Seeing none, Mr. Clerk, you'll call the roll.
Council Law 2016-011. Call of the election, special election, Ward 6 City Council. Council Kane.
Yes.
Council Kroll.
Yes.
Council DeBon.
Yes.
Council Finn.
Yes.
Council LaFleurs.
Yes.
Council Liang.
Yes.
Council Palmucci.
Yes.
President Hughes.
Yes.
Motion is adopted. Next item, assistant to this, designation of polling places for the April 5th, 2016 preliminary election and the May 3rd, 2016 City Council special election. Same 5 polling places as November of 2014 city election.
Is there a motion to call, made by Council Calhoun, seconded by Councilor Liang? Mr. Clerk, can I call the roll?
Council Kane.
Yes.
Council Kroll.
Yes.
Council DeBon.
Yes.
Council Finn.
Yes.
Council LaFleurs.
Yes.
Council Liang.
Yes.
Council Palmucci.
Yes.
President Hughes.
Yes.
Designated polling places. One more, accompanying order. Adopting election calendar for the Ward 6 special election beginning January 19th and ending on May 3rd with the Ward 6 city election. Primary election on April 5th.
Motion from Council Calhoun, seconded by Councilor Liang. Call the roll.
Council Kane.
Yes.
Council Kroll.
Yes.
Council DeBon.
Yes.
Council Finn.
Yes.
Council LaFleurs.
Yes.
Council Liang.
Yes.
Council Palmucci.
Yes.
President Hughes.
Yes.
8 members. That takes care of the matters. Number 13, Council Order 2016-014, an order from President Hughes, creation of a new city council committee to be known as Community Engagement Committee.
Maybe we could, on the item, I just wanted to briefly talk about the inception of this particular committee. After talking with some of my colleagues, in particular the newer colleagues on our council, that as a whole, we don't typically engage the community and those new residents that we've talked about, that we've acknowledged coming to the city, and also those folks that maybe in the past have not been reached out to quite this body as a whole. Certainly we do that as ward councilors, reach out to communities and to certain neighborhoods in community meetings. And this was an opportunity, I thought, to get the body engaged in the community of the city. So I want to thank those folks who have agreed, in particular Councilor Liang, who is going to be chairing this committee, and I look forward to establishing our first, or setting our first meeting and really getting out. This is a committee, or I envisioned this committee, and I know we've discussed it, Councilor Liang, Councilor Calmucci, and myself have discussed it as being really a committee of action, and really getting out there and trying to meet the people and engage those newer residents, those people who've been here maybe for a long time who don't typically interact with us on that community level. And again, we have acknowledged in the past that we have so many new folks coming to the city thanks to the great attributes of the city. So this is a way for us to really get involved with them as a whole. So I want to thank Councilor Liang for her willingness to steward this particular effort, and I look forward to working with the committee. Thank you. Do we need a roll call? I think we need a roll call
Sure.
on that. So,
No,
Mr. Clark.
On the creation of the new council committee, community engagement committee, Council Kane.
Yes.
Council Crowe.
Yes.
Council Devon.
Yes.
Council Kane.
Yes.
Council Song. Council Yang.
Yes.
Council Calmucci.
Yes.
President Hughes.
Yes.
8 members.
Thank you. Next one.
Next order, 2016-015, an order which previously appeared on the last council session calendar related to the underground economy, the misclassification of employees on construction sites. Councilor Finn.
Yes, thank you, Madam President, Mr. Shea. This actually was an order that I filed last year, and specifically what it really deals with, I'm happy also it's being co-sponsored by Councilor DeBona. And what it really addresses is, given the fact that there's so much development, particularly residential development, that's occurring within the city, that it becomes very important to understand some of the subcontracting types of difficulties that can go on. We actually received some testimony to that effect during the Avalon hearings and the like, of people who are not getting paid. But it's also ways of people avoiding paying taxes, avoiding health care issues, etc. And it's not strictly, an issue about unions per se, because also it affects non-union shops and their ability to compete as well. Because if you have people who aren't paying salaries, who are paying under the table, or doing different types of contracting schemes in order to avoid that, you have a very difficult situation. You also have a very difficult situation in terms of just even the quality of construction that can occur. We have community values here that are very strong. The City of Quincy, we are the founders, the founding place of the International Laborers Union. We hold to certain values, and oftentimes our ordinances reflect those values. But sometimes it's difficult, particularly in terms of enforcing some of those things and being able to limit what we consider to be practices that impact working families and ordinary people, and in many cases, a crime of what they do oftentimes with some of the undocumented labor that can participate in some of these projects. But my hope is to have some hearings and specifically some presentations on the underground economy, including perhaps representation from the Attorney General's office as well. But what I would like to do at this point simply is to refer that to the Oversight Committee. But if we could, I would like to schedule that at its earliest moment. We could actually have that presentation before the City Council.
Thank you. All right. Refer to oversight, and I know we'll get to that, and Council Calmucci is going to be chair of oversight. So
Next item is also from Council Finn, order regarding MBTA proposed development of the North Quincy Red Line Station parking lot. Requesting an update.
Council Finn. You're on. I don't know how to put you on.
That's okay, I am now.
Okay.
good friend and colleague, Doug Petro, I've learned to stare.
I don't close either.
But, no, this actually grew out of reading the State House News Service. I had noticed that MBTA was having a closed meeting, an executive session, where they were discussing the RR related to the development of the North Quincy Red Line Station. And that got me thinking in terms of the fact that I had known Councilor McNamee and I had been asked to assume some of the responsibilities related to Ward 6 during the present time. And Councilor McNamee, prior to his death, had actually sent out a letter to the community mentioning the fact that that NARPAR had been administered, or has been sent out. I believe that there are probably some proposals that are forthcoming very shortly. And what I'm really just suggesting is that we engage both the mayor's office and the MBTA in some of the issues associated with this development, because aside just from the North Quincy, which again, I have calls in and I've been waiting to be briefed by MBTA as well as that relates to that, but we also have the issue that many of you I'm sure heard on the campaign trail about the status of the Quincy Center garage and the proposed development for the future there. So I'm simply putting this in as a resolution again that I would think would best go to oversight, and that if we can try to engage both the mayor's office and MBTA in some discussion and just see if there is going to be, particularly in the North Quincy, engagement on the part of the citizenry in some way in that process.
Thank you, Councilor Finn. So just to oversight, do you want to try to refer the mayor as well?
Yeah, and a copy can be sent to the mayor.
Very well. Thank you. Moving along.
Next item, number 17. This is also an order being carried over. It's an order that Barbara Terrace, that we review a petition from residents of Barbara Terrace to become a public way. Barbara Terrace is in Ward 1. It's referred from Council Finn and LaForest in 2015. Gone to the engineering department. He says get a number of which steps of this.
And I know Councilor Forrest as well.
First off, I just want to commend the work of Councilor Forrest. As we know, this is always a long process. We had introduced it at the end of last year, and I was kind of under the assumption once that process was started, we were fine. I was checking with that, but I think what the clerk has decided was that it was best at this point to simply file it again. And we just need to stay on top of that and move that process. Because again, and I have to be, I've been through this before. This is a slow process, but at the same time, we need to really make sure we get it moving.
Thank you, Councilor Finn. Councilor Forrest.
Thank you, Madam President. So I just want for the ad-hoc viewers to see this on the agenda, right? Tonight isn't the acceptance. This is again part of the process. We received communication, I witnessed some of the papers last year, petition relative to accepting Barbara Terrace, which is a private gravel road, to become a city street. So it is something that legal looks at, it is something that engineering. We do not have a timeline turnaround from the administration on where that stands or any recommendation one way or the other at this point. It's just kind of, it's in the pending, in the pending file, and we're looking for an update. So if, through you to the mayor's office, if there are any updates I should be providing the residents, I will await that information from your office. But just for those viewers who are concerned about Barbara Terrace, just to clarify, this is not a forward movement. This is a kind of lateral, just putting it back in play in Councilor.
Thank you, Councilor Forrest. Refer to Public Works.
Committee and engineering.
Public Works and Engineering referral. All right, next item is.
Next item is number 17, Council Order 2016-018. This is also a reintroduction. This is a resident petition to the Mass Department of Highway for highway noise barriers in West Quincy. We also have 3 letters under communication site relative to this matter that need to be renumbered for 2016. Council comments.
I have nothing to add.
I think it speaks for itself. Well, this is a petition brought by residents of West Quincy who are seeking noise barriers. We accepted the petition, referred it to the governor and the state delegation. I know the state delegation is initially working on the letters that are coming in and correspondences are their response to the petition and their efforts to secure funding at the state level for this. So I trust that process will play out at the state level. Thank you.
Yeah. All right, so we will refer this back to the oversight committee? Or?
Sure.
Yeah. Next item, Mr. Clerk.
Next item is number 18 on our agenda. It's a gift. Eastern Bank, be it ordained the city of Quincy accept the following gift upon conditions attached and herein set forth. Donor Eastern Bank.
Motion to waive the reading.
I'm sorry, these are various receipts from Eastern Bank through the mayor's charity offering.
All right, motion.
Accept the gift and send the letter of thanks.
Okay, motion to accept the gift by Councilor Kroll, seconded by Councilor Devon. All those in favor?
I need to call roll on gifts, I'm sorry. Councilor King. Kroll. Councilor Devon.
Yes.
Councilor Finn. Councilor Clark. Councilor Yang.
Yes.
Councilor Calhoun.
No.
President Hughes.
Yes.
8 members of the gift. Thank you. Next gift. Going Paul and Jan O'Neill, gift $500, Purpose Dare Program.
Motion to accept the gift and send the letter of thanks.
Motion's been made by Councilor Kroll, seconded by Councilor Devon. Call the roll.
Councilor Kane.
Yes.
Councilor Kroll.
Yes.
Councilor Devon.
Yes.
Councilor Finn.
Yes.
Councilor Clark. Councilor Yang.
Yes.
Councilor Calhoun.
Yes.
President Hughes.
Yes.
8 members. Motion's passed. Another gift. Be it ordained the city council accept the gift upon conditions attached and herein set forth. Paul and Janet O'Neill, $500, Purpose Crime Prevention.
Motion to accept the gift and send a thank you letter.
Motion by Councilor Kroll, seconded by Councilor Devon. Clerk, call the roll.
Council King. Council Crowe.
Yes.
Council Devon.
Yes.
Council Finn.
Yes.
Council Clark. Council Yang. Council
Yes.
Calhoun.
Yes.
President Hughes.
Yes.
This gift. Next one is also a gift. Be it ordained the city of Quincy accept the following gift upon the conditions attached and herein set forth. Donor Ann Demoni, gift is $50 to the fire department.
Motion to accept the gift and send a thank you letter, please.
Motion made by Councilor Kroll, seconded by Councilor Devon.
Councilor Kane.
Yes.
Councilor Crowe.
Yes.
Councilor Devon. Councilor Finn.
Yes.
Councilor Clark. Councilor Yang.
Yes.
Councilor Calhoun.
Yes.
President Hughes.
Yes.
8 members, the gift is accepted. Another gift, be it ordained the city accept the following gift upon conditions attached. Again, Ann Demoni, gift is $50, crime prevention.
Similar fashion, motion to accept the gift and send a thank you letter.
Motion has been made by Councilor Kroll, seconded by Councilor Devon. Clerk, call the roll.
Councilor Kane.
Yes.
Councilor Crowe.
Yes.
Councilor Devon. Yes. Councilor Finn.
Yes.
Councilor Forrest. Councilor Yang. Councilor
Yes.
Calhoun. President Hughes. 8
Yes.
members. The gift is accepted. 2 more gifts. The next one. Be it ordained the city of Quincy accept this gift upon the conditions attached. Anastasios Kasakis, $100 Dare Program.
Motion to accept the gift and send a thank you letter.
Motion's been made by Councilor Kroll, seconded by Councilor Devon. Mr. Clerk, you'll call the roll.
Councilor Kane.
Yes.
Councilor Crowe.
Yes.
Councilor Devon. Councilor Finn.
Yes.
Councilor Forrest.
Yes.
Councilor Yang.
Yes.
Councilor Calhoun. President Hughes.
Yes.
8 members, the gift is accepted. The last gift of the day. One, be it ordained that the city accept the following gift upon the conditions attached and herein set forth. Donor Anastasios Katsakis, the amount of $100, and again, crime prevention.
Motion to accept the gift and
Send a
send
thank you letter.
by Councilor Kroll, seconded by Councilor Devon. Mr. Clerk, call
Councilor
the roll.
Kane. Councilor Crowe.
Yes.
Councilor Devon.
Yes.
Councilor Finn.
Yes.
Councilor Forrest.
Yes.
Councilor Yang.
Yes.
Councilor Calhoun.
Yes.
President Hughes.
Yes.
Gifts accepted. Next one is number 25. It's a resolve from Council Calhoun relative to the special election for Ward 6C. I have in front of me, Bill 26.
Councilor Calhoun.
I withdraw the resolution.
Okay. Withdrawal. Withdrawal. Great.
Next item.
Another.
Next item is discussion and vote, if necessary, go into executive session relevant to the SEMA litigation. Roll call vote must be taken.
Very well. I'll invite Solicitor Timmons up to, if I could, just give us a brief statement. We are not going to, unless somebody moves, I will be moving. Is there anybody who's moving to go into executive session for this particular item? All right. Great. So we will discuss the executive session and listen to this in the general meeting. And thank you, Solicitor Timmons, for sticking it out with us and staying until the end to give us a litigation update.
It's one way to characterize being in the podium. You know, thank you. And I do, I will say Council President Hughes called me earlier today to talk about the question of executive session. By default, it was on the agenda in that manner because it is related to litigation. However, in this particular instance, the fact of the matter is the litigation is included in the decision of the land court. And what I wish to do this evening is discuss with you the decision and then discuss with you, because this body is the permit granting authority, discuss with you the relative merits of filing an appeal in the matter and whether you might wish to do it.
One point of order.
Yes.
I just, and again, Jim, you know what I'm going to ask you with this too, but should we be doing this outside the context of the SBGA, or would it be necessary to recess from the city council and call an SBGA, and or should we give a notice regarding a special permit grant thing? Well, related to this, or is this something you really report back to the council?
Yeah, it's an excellent point. There's a couple of ways to deal with it, because the thought I had is getting the discussion going forward, which we can do. The SPGA is not voting on the permit or not considering the permit. We'd be talking about the litigation, and you're correct about making that distinction, and that perhaps we should convene as an SPGA to take a final vote. But I do think it important to at least discuss the nature of the decision and what would be before you and the timing of what is before you. And we, the thought was to do it at the meeting this evening. But you make a very appropriate distinction, something we alluded to earlier about the difference between the permit granting authority and the city council. And the newer members may not be fully aware of the distinction, but you wear two hats. And it was the permit granting authority which took the vote here. But that's one of the discussions that I wish to have with you about the nature of the decision here. It was not the intention to stay all that long, but that is an important distinction. I'd just like to say that there was some discussion in the decision that I wanted to call to the SPGA's attention, because I thought I used the term disappointing when I was speaking to a newspaper reporter, because that's how I felt. I thought that the permit granting authority, the city councilors who sat in these seats, worked very earnestly on the matter, and that it was a very difficult matter to deal with. The decision at its core made a conclusion that I take strong issue with and will continue to take issue with, and I think it forms the genesis for consideration of appeal. However, I'll go a little further on that. The judge says on on page 44 of his decision. For good reasons or bad, the city simply did not want an Asian American supermarket in this prime location. And he goes on to say, I need not and do not decide if this was racially discriminatory. I tend to think it was not, except in the sense that such a supermarket would draw a larger Asian community in Quincy and thus potentially affect its political, demographics and dynamic. That was a driver for the outcome in this case, was that the city did not want an Asian supermarket at that site. And consistently within the decision, the judge references the city. He merges the office of the mayor and Mayor Cope and other executive functions with the permit granting authority. And you clearly acted distinctly from the mayor's office and from several of the other consultants. There were some logistical issues that occurred over the course of the proceeding, like, for example, one of the peer review engineers, you may recall, those of you who were present, Ms. Christine Ketchus, who was an employee of Niche, came out and did field work, did a lot of the work, and testified at trial. She left Niche, went to a different engineering firm. Then she went on her honeymoon, and she was gone for the 2.5 or so week period before the trial occurred. For that reason, I didn't get to spend a lot of time with her. We didn't think it was going to be worth prepping before her honeymoon. So I spent time with her on the day of her testimony, and she testified. And there's criticism in the case of her testimony and the fact that she only spent an hour preparing for trial. Well, she had gone to a different company. She did a lot of the field work, and I was quite surprised when I found that statement by the trial judge in the decision. I think some of what the judge did was he saw some things here that rightly or wrongly sent signals to him that I think caused him to make conclusions that I strongly disagree with. Not so much from a legal perspective, but he specifically said from the bench that he did not see any evidence of racial animus during the course of the trial. And that was the basis on which much of the challenge was raised in the trial, was animus toward this particular applicant. The testimony that was proffered at trial about this use in Asian American supermarket was that they sell everything fresh. And as a result, shoppers will go there 2 to 3 times a week. Unlike Stop and Shop or other markets of that nature like Hannaford or Stars, you're looking at the face of a Stop and Shop shopper who's eating food filled with preservatives. Things like peanut butter and bread that comes off of a shelf where it's all Nissen or whatever. The issue with C-Mart was because everything is fresh, people go back there 2 or 3 or 4 times a week. And once they develop a regular following, which they've successfully done, they tend to generate traffic because people are coming back there regularly. That was the discussion, to the extent there was any discussion about the particulars. And then the other criticism that was made of this body as permit granting authority was that didn't participate, didn't offer, didn't engage in mitigation discussions. Well, one of the big problems with this site, as you're all well aware, is that at Billings Road and Hancock, there's a fully actuated intersectional red light system. And then you go down and you cross the street that along Hancock that C-Mart's located on, or the building is located on, Hayward. That's got a pedestrian actuated light. And then about 200 yards to the south is the infrastructure that went in for Hannaford's. There's a red light there. There's red light systems already in play along Hancock that it's very difficult based on the Institute of Traffic Engineering standards. They want certain distances between actuated red lights or synchronized red lights that are on the system. So the discussion that we thought occurred and that we put forth at trial was that that was a constraint for this body and for the applicant in terms of creating mitigation along Hancock. You already had existing red lights and you couldn't add the type of system that Hannaford's had done 200 yards to the south. In addition, just to the west of the site is the MBTA train track, which completely bisects the city. So the problem is there were a number of issues raised in this decision that I think cast some of the decision-making of this body in a negative light, and the motivation for it more important. Now, I will tell you that since the decision has come down, I've had 2 discussions already with counsel for CMART that have been extremely collegial and affable. He has reached out, continue to talk, and I know that in talking with the mayor about this in the mayor's office, that the mayor has, he's prepared, I should say, he's prepared to work with this body, if it were the intention of the body, to try to work with the applicant. My recommendation to you, and I'm making the recommendation publicly because it's not a big deal and I'm not giving anything inappropriate as far as litigation strategy, but my recommendation to you is that we consider filing a notice of appeal in order to protect the city's rights. I should say the permit granting authority's rights. But that does not necessarily mean that we have to act on the appeal or go forward. You have a 30-day window to file a notice of appeal. And that window starts the date the decision is docketed. So that's, I believe, the January 7th date. That's the date the decision is dated. So I would ask this body to convene again as permit granting authority, at which time we would take a vote on that. But I wanted to highlight for you collectively, rather than having individual discussions or private discussions, where you consider that and consider the option of filing a notice of appeal. And should we wish to go forward or should we wish to have a discussion, we could do so. And I would happily do that about other issues that are in the record. Because I read the decision and I've reread portions of the trial transcript where I believe there's indicators otherwise of certain things. However, I'll also say this. I think it would be important for each of you individually, those of you who were on the body before and then the new members, to just give some time and thought and consideration and take some time to reflect on it. And then if you want to ask me questions individually, I'd be fine with that. We don't have to make any sort of decision that's going to continue the adversarial relationship. We don't have to make any sort of decision that's going to set up adversarial positions right now. Mr. Murray, the lawyer for CMART, has already asked me about what we might be doing, and I indicated this very thing, that we might file a notice of appeal, but try to keep the discussion going. He is filing a motion in court. They're entitled to recover their costs, and he's going to file that in court, but that doesn't necessarily mean he's going to act on it yet either. He wanted to let me know it was coming, and he wants to keep the discussion going. So I would indicate that so far, or at least initially, there have been very positive discussions between the parties, and we'll try to continue doing that. But I just think that the members should be aware, in light of the fact that the decision came down at a time when I wasn't able to speak with you, other than individually, of just some preliminary thoughts. And then we can convene as an SPGA, at which time you could be taking a vote on whether to proceed with a notice of appeal or not. And it doesn't even necessarily require a vote, actually, but I would like to do that. I appreciate the opportunity to discuss some things with the body. I do think there are some issues here, but I also know that it may be up to the body going forward to consider the bigger picture items. One other thing I had meant to mention, one of the issues the judge raised was when Councilor Hughes first came into office as Ward 5 councilor, and CMARC's actually located in Ward 5. It's not in Ward 6, as one might believe, based on Councilor McEnany's advocacy when he was in office. But when Councilor Hughes came into office and sat down and asked questions of me, one of the things she talked about was extending the traffic study that had occurred. The first traffic study in this matter, prior to her election as Ward 5 councilor, stopped at the Hannaford red light, which is 200 yards south of Hayward Street. When Hannaford's came in, they had to study all the way down to the intersection of Elm Ave. So in discussing with Councilor Hughes about this, she said that she feels they should study the same area because there will be impacts in Wollaston, from Wollaston and in Wollaston, and one of the study areas standard. And in his decision, the judge construed that somewhat negatively. So this is the type of thing I'm talking about, where things that were done for a very proper motive, and appropriate reason, were construed by the judge, or at least in his findings when he wrote his decision, once he had made his decision. It was held up as a negative. So there's a question in zoning cases whether a trial judge has essentially, he's inserted his own opinion in the matter, as opposed to and kind of overruled the SVGA. Trial judges are not allowed to second guess or overrule SVGA decisions locally. What they do is they determine whether they're proper or pretextual. Well, this judge had concerns and thought there was pretext, but I think there's a clear record that some of what went on that he was concerned about, such as what I just mentioned about the expansion of the traffic study area, was not pretextual. That doesn't mean we keep going on this in terms of litigation. We may want to try to work toward resolutions, but those are the types of considerations that I just asked you to start thinking about. And I think we'll have one more meeting about whether we file the notice of appeal, which again doesn't require us to do anything other than protect our rights. And we could continue moving forward from there. So that was the reason for the discussion this evening with this body, as opposed to the SVGA, because I think we need a little more time on it, although we're on the 30-day clock. Thank you.
Councilor Forrest, and then Councilor.
Thank you, Madam President. Solicitor General, just on that, you referenced that they could recoup, CMARC could recoup legal costs. Would we be using any outside counsel? Has there been any cost of taxpayers? Has been handled in-house by your department?
So far, this was a case that I handled. There's been no legal fee expense. There were fees incurred for traffic engineering, but they were actually paid by the applicant. It was the peer review. We did pay the traffic engineers from niche expert fees.
Just for testimony?
I beg your pardon? Yes, for their trial testimony, yes.
So, just a couple of procedural questions on the SVGA process. So, as this decision comes back saying the city, that special permit granting authority should grant CMARC this location, obviously we have a lot of concerns in the traffic. Was a big part of the discussion that I remember. Procedurally, does that restart the clock in SVGA and redo a new permit? Do we have to grant the permit as presented of us, some of us here to go to no on? We reopen, procedurally, how does that work? And now, particularly with the new council.
What the judge did was he filed a decision with the court, a judgment, and within the judgment, he issued what's called an order of remand. He's remanded it back, which means sent it back, and his order says for the issuance of the special permit. But he's added, subject only to such reasonable mitigation conditions as may be imposed by the council. So that means that the SPGA could hold a hearing regarding mitigation. And I would anticipate that that would be a step that should be considered and perhaps should be taken because it would influence outcomes here. That if we think that appropriate mitigation can occur, we should start negotiating as soon as possible with CMAR. First identifying it and then working with CMAR to see that it's implemented.
So since it been changes to the abutting intersections, right, the West Swan Street,
Yeah,
does that not impact the Council Hughes' question about it backing up? Does that get to be addressed by the body?
Yes, those are the types of things. It would be similar to what happened when we were doing the project in Council Calmucci's ward, Ward 4, where Raschuti Drive and its intersection with Willard Street came into play, and there was some argument about how to deal with that. And we were looking at the picture of how that intersection is developing and what might happen going forward. Well, back at the time when we were considering the CMART application, the North Quincy Hancock-Swanham intersection was in design, I believe. It wasn't even underway. Well, now it's all implemented, it's functional, and it may be the case that with some refined traffic study, we can make some determinations about how things might work efficiently along Hancock Street. There are things like that can be looked at.
Thank you.
Council Calhoun.
Through you to the solicitor. No costs have been awarded to date, right?
That's correct.
And there's nothing in the decision that discusses costs. The litigant, the other side, didn't seek the costs in that suit.
Right, well, really, the only costs that, and I can ask Mr. Murray, but I anticipate getting a motion soon, and I'm happy to share with you, but he took some depositions. And then there would be preparation with the engineers for the trial testimony. And then the documentation was voluminous in the end, most of that, so. I'm not certain what it'll be, but I'm happy to share it with everyone.
Is there any
As we share the decision.
Is there any provision of law that would entitle them to costs and other civil rights, not a 93A? What's the...
No, this was just a straight zoning appeal, and it's continued to be treated as a zoning appeal. There's not been a claim under a Civil Rights Act which would entitle them to damages and legal fees. There's no claim of that nature. This is a straight zoning appeal. And costs, as you know, go to the civil party that prevails. That's the nature of the application here. I think that some of the judge's findings, and then, there's abundant trial evidence that it was not the result of animus, that would trump any sort of civil rights appeal.
And I've read the court's ruling. I don't say any comments I have for it, mixed feelings about it, but I'll say any comments I have for when we meet as the SPGA. But I guess I have two concerns. First is relative to mitigation. When the SPGA meets, the only consideration is relative to mitigation.
That's correct.
Right. And there's no mitigation plan currently before the SPGA because one was never developed by the city, which is noted in the judge's ruling that was one of the issues he had. The city didn't even discuss mitigation and how to offset some of the negative impacts. They just said no, or the SPGA just said no.
Right. Well, I think what happened was the judge said the SPGA didn't discuss it, and that was correct primarily because of the denial, but it had been discussed over the course of some very extensive discussions by the traffic engineers and the executive branch over the course of the summer. You may recall it was remanded. Yes. Then we convened briefly before the summer break, and during the summer, the parties worked a lot together. I do know that part of CMAR's presentation during the hearing was that they did propose some mitigation. Yeah.
So, I presume that we are going to schedule an SBGA meeting this evening. Can I request through you that some written communication is made from the planning department or whatever department the mayor sees fit to send it from to the SBGA on the question of mitigation and what that body should consider? I don't think it's incumbent on the SPGA to start pulling mitigation ideas out of the air. We need to utilize the professionals we have in the employ of the city.
Well, the sequence I see is that at our next meeting, which will be first one in February.
February 1st.
Right. We would consider the prophylactic notice of appeal and then a schedule going forward. Between now and then, I'll talk to Mr. Murray and CMART about how they wish to proceed, and I'll also convey that to you at the first meeting. Because we've had several productive discussions already, and I want to see those continue.
So what about...
As I presume the body does.
Right, so what about something again?
Yes, no, absolutely, that's noted, and I will do that.
Because from my perspective, and my reading of that order is, this is not a question of if the permit will be issued, but how the permit will be issued, given the mitigation. It's not a take another look at it, fellas and ladies, and let me know what you think. It's issue the permit, I'll let you decide mitigation. That's the judge's order.
Right, that's an absolutely correct characterization of the code. The only impediment to that would be, were we to file a notice of appeal and successfully argue that this was a case of substituted judgment by the trial judge.
Which you and I can discuss offline. There's an argument to be made for substituted judgment from the body. Obviously, I was in the non-prevailing party during that vote in the SPGA, but I can see the argument that could be made relative to the judges, some of the judges' findings, which were different than my remembrance of the events of that hearing, those hearings. But that would bring up my second concern. Are we nominal defendants, in your opinion, in this action, the SPGA?
Yes, not just in my opinion. You are nominal.
So in the instances in which we're nominal defendants, meaning we're named, but we're really not the ones that...
Your official capacity.
Right, in our official capacity. When we're nominal defendants, it's then incumbent upon the executive to defend court cases and make decisions in litigation.
Well, SPGA is different. It's up to the body whether you feel we should appeal it or, I mean, it's your permit. Your permit denial, actually, that's in question. So it really would be up to this body. That was one of the issues I ran into some time ago, and I think most people are aware. Councilor McNamee and I were friends as well as being professional colleagues, so I can invoke his name and blame him for something, even though he's not here to defend himself. But he had some questions during the first round of CMART where he was concerned about actions I took that I thought were appropriate and in the interest of the body, but he challenged it a bit. So since that time, I have brought things back to this body, even to the point of having you read decisions before they're signed and endorsed by the clerk. I give you the opportunity to review them to make sure you're satisfied with the written decision. So it really is this permit granting authority, but I'm very happy to provide as much advice and thoughts and do so publicly as you may need.
So I would request a legal opinion from you or a memo from you, a letter from you relative to the legal basis for appeal and why that would be in the best interest of the SPGA. Because after I read that decision from the judge, well, you can see some argument on the other side, from your perspective, on the other side of what the judge's opinion is. I look at the applicant, and from that perspective, I would imagine they want quick action on the judge's decision, which is cut and dry, it's issued a permit. So to contemplate an appeal, even if we have no intention of moving forward with it, is stopping the clock on a property that the applicant's been paying taxes on for a number of years while this has been. And I don't know that a single abatement has been given on any of the property taxes he's been paying a multi-million-dollar property.
Now, the docket number's 09, so it's been around for a while.
Right, so I have some concern, I'll tell you, I have some concern as someone who sits on the SPGA, that we're not scheduling the meeting to conform with the judge's ruling, to issue the permit with conditions, that we're not just discussing the mitigation and the issuance of the permit, that we're contemplating an appeal, and I certainly wouldn't want, I speak for myself alone, I wouldn't want to say, I won't take a vote as an SPGA member to file a notice of appeal for the purpose of slowing the clock down and giving us more time. This thing has been kicking around like a bad penny for too long. We need to make a decision and move forward. There seems to me to be only one issue here. It's not if the permit gets granted, but how it gets granted with what type of mitigation. So I would like to see us resolve this matter at the next meeting in the SPGA rather than file a notice of appeal, negotiate with them, kick the can down the road. To me, it seems a little like rearranging the deck chairs on the Titanic. You know, this is the thing's decided here. It is what it is. The judge says remand the case back to us, to the SPGA, to issue the permit, not to decide whether or not to issue a permit. We can't get any more cut and dry than that. The only thing we can consider is whether or not to issue mitigation. So I would hope that in the interest of conformance with the judge's ruling, we would be moving in an expeditious process. And an expeditious fashion with the SPGA. Yeah, okay.
Yeah, I'm not implying we kick cans down the road or delay anything. What I'm saying is file a notice of appeal, which does nothing as far as impacting what this body might do, and then negotiate. But I'm happy to go further with the discussion, but if any of you read that decision, it's very concerning, and I think much of it's not warranted.
I agree with you. I have concerns. I discussed that with you.
So I don't like to, I just want the body to be aware that, does a decision like this stand? You know, he talks about one of the, something called a travel time delay study, and says that, you know, he talks about that fully credits the applicant's traffic engineer. And during the course of the trial, during the travel time delay study, I cross-examined the engineer, and he acknowledged during my cross-examination, after he provided copies of it, that there was a problem with the numbers. They had guys out there who were saying there were red lights at Chapman Street and Bass Street, and they were stopped at the red light for a certain period of time and then proceeded through. And there are no red lights there. So the underlying data that this engineer worked with was not accurate, and that came out of the trial. Well, how then do you credit the engineer fully as he did? That's, to me, is a mistake, and it's a clear error. And that, as you know, this is trial court level, and it's why appeals courts are in business in the Commonwealth. The primary reason for overturning the zoning decision is substituted judgment. And I can understand why the judge had some of the concerns he did. But some of the fact-finding that occurred here is troubling, and that's, I just want to call it to the attention of the body. I'd ask you to read the decision again. And I agree with you that, and I said this earlier, that moving forward is the way we have to do it, but in a manner that I think is appropriate. And I'm just looking to protect the interests of the body relative to this decision, but continue to move forward.
So is there any reason
not
why
merely,
we can't,
I was just going to say, I'm not merely trying to proliferate what has gone on here. I fully agree with you. And I think that if that's the will of this body, I know the mayor is prepared to provide assistance and to work going forward. But you know, the concerns all along with traffic and the impacts wasn't unanimous. So that's what we have to work with.
the way I see it, perhaps I'm wrong, there's three options at the next SPGA meeting. There's three options that the body has. grant the permit as instructed in the remand without mitigation, if we so choose, grant the permit with mitigation, and file a notice of appeal. Those are the only three options that would be available to us at the next SPGA meeting.
Right, and 2 and 3 can both happen and are not mutually inconsistent. They're in fact mutually consistent. That happens all the time. The parties file notice of appeal and then they talk. And that is absolutely what I think is the best course here.
So I'm
That's why
fine.
we're having this public discussion. The president in whose ward this proposed operation would be located has had this discussion, and so we understand or agree.
Is there any reason why we can't have all options available to us fully vetted by the time of the next SPGA meeting? So on the appeal, we have a letter from you or a memo from you as to why it would make sense to appeal, what the basis of that opinion is. We all value your opinion as expressed tonight and in an earlier vote. So you give us your opinion as to why an appeal would be the best course of action if you think it is, and also have concurrently the planning department offer up some ideas, recommendations for mitigation so that when we meet, there's no reason for delaying whatever action the body chooses to take at that time.
That's correct, and there is no reason. I'd be happy to ask Mr. Murray, the legal representative of CMAR, perhaps any CMAR representatives who wish to be present, to come at that time, if that seems appropriate. Just to look at options.
Thank you.
Thank you. Council.
Thank you, Madam President. Just as a follow-up, the mitigation, does that then get approved by the judge?
Pardon?
The mitigation, does that go back to the judge for approval?
Well, it would only go back to the judge if the SPGA issues the permit, we're done. If we, and if we do so with mitigation, then we'd be all set. I'm presuming that if we were to go forward in that manner, that the mitigation will be agreed upon. We would only go back to the judge if this body felt strongly that there were certain mitigation measures that were necessary and appropriate, and CMAR felt equally strongly that, that's beyond the pale. And then we present it to the judge.
So hypothetically, I think there's not really an opportunity at that location to get traffic over the train tracks, right? There's another bridge onto the front from that area, from another area. Getting traffic, that would be a exorbitant
Again, I
expense.
think this level of discussion, when we get back, this is the thing that concerns me, is that discussing the merits at this particular point in time, that would be discussion better preserved within the special granting authority session.
Right.
Because
Right, and I don't know if that's what
we're not-
So-
we're not being-
I'm just trying to get a scope on the mitigations. That wasn't going to be exorbitant.
Well, I think
It's
that,
something-
again, I think that it's critical, because there's other things within that judgment that are more technical in nature, where we slipped up, for lack of a better term, in terms of even if the intent wasn't, even if it wasn't pretext, it could have the appearance of pretext. And that's one of the things I just think we need to be very conscious of, concerned about. That if we're going to have that discussion, we announce an SPGA meeting, we set up that time, and we have the discussion.
The point of this, though, is to have you be informed, because unfortunately, logistically, it's difficult for this body to act expeditiously.
No, but
And so I just wanted to get things like this aired so everyone's aware of what.
I agree, but the point is, we have 1, 2, 3, and potentially 4 new people who will be sitting in the future. If we start making statements outside the context of SPGA about the nature of traffic or the different things, I'm just very concerned about that. I think we're better off.
I don't think we're doing that. And I would make sure we don't do that. I agree with you.
Almost, I was just trying to put it towards mitigation. If you're throwing something out there, and what's the judge's role at that point? Does it need their approval with what we have, or as long as the applicant's agreeable, we're good to go? If the applicant's disagreeable, back to the judge we go?
Correct. If we can't agree on something, we go back to the judge. That's right. But I would anticipate that if we get on that road, it would probably be productive matter.
Thank you, Mr.
All right.
Chairman. Thank you. All right, moving on, approval of previous meeting? All right, move to the approval of previous meeting minutes from the meeting of December 21st, 2015. Is there a motion to accept the minutes? Motion has been made and seconded by Councilor Crowell. All those in favor?
Aye.
Aye, the ayes have it. Communications?
I have several, Madam President. The first communication I have is dated December 16th, it's from Thomas Tinlin, T-I-N-L-A-N, who's the Administrator of Mass Department of Highways, relative to the noise barriers in West Quincy. My suggestion is to file with the new auditor, and I'll distribute it. The second one is from, on the same subject, it's from Senator Keenan, Representative Ayers and Chan, relative to the mailing they did on January 4th to the West Quincy neighborhood. I'd like to file that. I'd like to suggest we file that with tonight's law in Council Convolution.
All right.
And the last one is another letter from Administrator Tidlin to Senator Keenan, which he approved with the fact. So with everyone's permission, I'd like to file those with that law.
All right, thank you.
The next 8 are the newest in the first traffic from the year. The first one's from Council Crowell, add a handicap parking space at 56 Burns Ave.
Ordinance now.
From Council Kane, add a handicap parking space at 91 Farrington Street.
Ordinance now.
Third one is from Council Kane, remove the handicap parking space at 120 Safford Street.
Refer to ordinance now.
Next three are from Council Calhoun, add no parking tow zone on west side of Hayden Street, Loring Street to Willard, Hayden Street and Loring Street to Willard Street.
Ordinance, refer to ordinance now.
Also from Council Calhoun, no parking tow zone December, January, February, March on the east side of Hayden Street from Loring to Willard.
Refer to ordinance now.
Council Calhoun, remove the no parking sign at 65 Hughes Street.
Refer to ordinance now.
And Council Hughes has 2, add handicap parking at 1 Bedford Street. And
Okay, refer to ordinance
And
now.
another one, add handicap parking at 70 Old Colony Ave. These are already advertised and will be ready for the next agenda, next council meeting. The next communication is from Dennis Regan, who's the permanent representative from New England for gas construction and maintenance for National Grid. It's to install and maintain approximately 1,125 feet, more or less, of 12-inch gas main in Quarry Street from the existing 12-inch gas main at building number 258 easterly to the proposed 8-inch gas main for Avalon Way, which is a private way for the new development on, depending on which side of Quarry Street you're going down, Avalon. A public hearing is necessary. I have all the copies of the agreement and the notice of butters here. We can probably set a date later in the meeting.
Okay,
Public hearing necessary. Those are all the communications I have.
thank you, Mr. Chairman. Unfinished business from
I have none.
proceedings. Reports of committees, seeing none. Presentation of petitions, memorials, and remonstrance. Chair, recognize Councilor Calhoun.
I actually had a communication. I
Oh.
apologize if, I believe we all received, we don't put them in as communications. This is a revised notice of public hearing from the planning board. When it comes to all of us as councilors, I asked this when we entered it. As a communication, it's relative to a public hearing being held on Wednesday, January 27th, 2016, on the application by Boston Scientific Corporation to add a FedEx ground distribution facility at 500 Comanche Boulevard. Council McAdoo would yelled at me for getting involved in Ward 6 business at this point, but I had a question to the representative of the mayor as to what effect this project would have on the TIF agreement that this body signed, if any, or approved.
All right, did you want to answer? Recognize.
Through you.
I was wrong. Yeah, Yes, thank you.
So we'll certainly take a look at that. That is the first hearing on that subject. And we'll be having some further discussions with the folks from Boston Scientific and this body.
And the only reason why I asked, it just raised a red flag to me, is as the project includes the reduction of footprint, the existing 471,000 square foot warehouse building to 373,900 square feet. And I'm wondering if the reconfiguration of the building has any implication on the TIF agreement, the number of jobs, the number of expenses and equipment that they agreed to purchase. So
Council.
I'll let you that in as a communication to the body, eagerly await the response from the mayor's office.
Thank you, Council Calhoun. Also, I think we had a
I have a remonstrance after.
a remonstrance. Okay.
Memorial.
Say it again. Oh, on the motion, or on the point. Council
On
Hart.
communication, what, a lot of times the ward council takes the lead on constituent communication.
Yes.
Has there been, I read that, but with some interest as well, knowing to be a vocal, what's the term, representative, typically speaking on that, has there been any communication to the, Marina Bay Neighborhood Association, anything, any, neighborhood meeting held, any introductions to what their expectations are?
Yes, Mr. Walker.
Through you, Madam President, Thorne originally did, at the mayor's request, reach out to Council McNamee. At that time, there was some preliminary discussion of having a community meeting. Since the time of Council McNamee's passing, Council Finn has stepped in, and to my knowledge, I believe is rescheduling a community meeting on this subject. For that very reason that they
Are
can
we still
actually.
discussing the Boston Scientific?
Yes.
There is going to be a community meeting. What's going to happen is the meeting on the 27th will be kept open, and then they have agreed to have a community meeting after that date, the 27th as well, for the next meeting.
Okay, so technically, though, the notification as far as butter notice is 300 feet. It's not really going to pick up any of the abutters who are concerned, Marina Bay residents or planning commission.
I believe Council Finn has been taking over the role of ward counselor, and so.
I've already discussed this with the Marina Bay Association, and we're going to get the word out on a larger scale to folks that are generally impacted.
I appreciate that. I just, my last question, is that a chapter 9 property or? I'll check with the planning for that. Offline, thank you.
Thank you.
Okay.
Yes, Councilor.
I'm also happy to delegate to any of my colleagues on the council who should step in on any of these projects.
Good job. You seem to have it under control.
Exactly.
Fine job.
There's 6 people out in the audience tonight who are willing to take a place, so there you go. All right, a continuation here, presentation of petitions, memorials, and remonstrance. Yes, Councilor Calhoun.
Thank you. It is with a heavy heart that I would like to offer a memorial for Mike Mullane, who passed away between our previous meetings and this evening. Mike Mullane was a retired vice president of the International Association of Firefighters and vice president of the Massachusetts AFL-CIO, a veteran of the United States Navy. He was a Quincy resident of North Bayfield Road. Mike was born and raised in Dorchester. He graduated from Boston Technical High School before joining the Navy. After returning home, Mike joined the Boston Fire Department, where he went on to lead union activities on behalf of his fellow firefighters. As an individual, Mike was a firefighter and a labor leader who fought ferociously for safe working conditions for his fellow firefighters. He will be sorely missed by all who have the pleasure of knowing him, and his legacy will stand to be reflected in the improved standards he helped usher in across the state for employees such as the firefighters that he served with. So I ask that we dedicate this meeting in his honor.
Thank you. Thank you, Councilor Calhoun. Any motions, orders, and resolutions? Oh, the presentation memorial. Motions, orders, and resolutions. Yes, Councilor Ben.
Probably fits more in the category of petition, but it's more of a request to Mr. Walker in the mayor's office. And it's an interesting thing we were discussing mitigation, because one person's mitigation and maybe another person's not a desired thing, but we've actually had something that we can discuss with the Ward 3 councilor as well, but on Common Street, there's an issue related to the crosswalk. And to one of our constituents that had referenced them, that these things just don't simply happen because of mitigation. There's some type of engineering, or some type of study that goes in to determine if the crosswalk belongs where it does. I was hoping that you might be able to get us access to that, in roughly 50 Common Street. But if you're aware of any study that's been done in relation to that, I appreciate it if you get back to me on that.
Thank you. Anyone? All right, scheduling of committee meetings and public hearings. Yes, Mr. Clark.
Madam President, through you, the councilors Kane and Calmucci, I have this National Grid request for Avalon, the length of Upper Quarry Street, 1,100 feet. May I suggest February 1st at 7:25? Or is that too early?
Yes.
I mean, too early in the day.
May I ask you if Avalon Bay is going to repay Quarry Street, Joe? Do we know?
Are you asking me in the process about this?
Yes.
Only Mr. Reed is going to ask me. I haven't heard from anyone else. We just got it today. It's not old. It hasn't been languishing around with the holidays.
I'm fine with scheduling a public hearing, but it has to just be sent over to the, this petition, National Grid, sent to the DPW with requests for the impact that this would have on the roadway. And 1,200, 1,100 feet digging up Quarry Street is a heck of a road over there. So, happy to put it on for a short date so that we can have a hearing. What we do after that is,
Well, if we can get the public hearing out of the way, we can pass or we can stay in Public Works Committee.
Did you want to say something? February 1st, so we said
7:15,
7:15.
because there's a lot of mailing here, and I want, if we're gonna do it, we want to get it right.
Did we want to set a SPGA for around that time? Solicitor Timmons,
We can do it, so we can
Solicitor
do the
Timmons,
SPGA
SPGA,
on
February 1, yes.
Please, thank you.
Yes.
That will be said. Why don't we do the public hearing at 7:10 and the SPGA at 7:25?
7:25. Okay.
Just need to be dated. I have no other scheduled
All right.
meetings.
See, any other scheduling committees? Yes, Councilor Ben.
If I could, and again, I request of the oversight committee, but I really would like to have a presentation related to the underground economy. I was wondering if there's a time suitable to the chairman where we might be able to have that, or if, we can talk about it, perhaps even moving it out of the council agenda, to do it that way.
Councilor Calhoun.
I'm happy to, I can discuss with you outside of the meeting who you'd like to appear, who we should formally invite. So I leave it to you. We can put it on. You can put it on the council agenda. I have no problem with that. I'm happy to hold a meeting of the oversight committee on a night that's convenient for both of you.
February 1 and then 16.
February 16th?
Yes.
We tentatively put something in for 6:30 on the 17th.
6:30 on the 16th.
On the 16th, and then I will confirm that.
6:30 or 16th.
Chairs.
Oversight. 16. 6:30. Councilor Crowe.
Thank you. I'm actually going to step back to 2-1. I think you said 7:10 SPGA and
Yeah.
then National
No,
Grid.
National Grid 7:10, 7:25 is
Okay.
PGA.
So obviously the items around the MSBA and window replacement program.
Oh,
Yeah, I chatted with Mr. Walker. I know we've seen some of these presentations, different formats, different schools being targeted. I mean, there's a half-hour presentation. Does that sound relatively in the ballpark? And if we needed to, we could bring it out of the committee later on in the meeting. I know that there's just some time sensitivity when you go on by both of those types of activities.
Yes.
On the first.
Yes. So 6:30 finance, 7:15, 7:10 National Grid. 7:10? 6:30 finance. Okay,
Thank you.
thank you.
Anyone else? All right, I would take a motion to adjourn. Nobody? So moved, all right. All those in favor? All right. Thank you.
Great job, man.
Thank you very much. Thank you. Exactly, yeah. It's called. Like, lots of ice, yeah.
Be careful of you, be careful of
That's a
Darryl.
stick one, right?
I said to her,